1990 as amended. This meeting of the Committee of Adjustment of the City of Toronto is called to order. My name's Larry Clay, and I'll be chairing today's session. Panel members today are Dino Lombardi, Katie Plaitzer, Phil Gauche, and Ryan Bissonette. And our Deputy Secretary Treasurer today is Sabrina Salatino. We acknowledge the land we are meeting on as a traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid, in-person, and virtual format. Some applicants and participants will make their submissions in person, and others will participate virtually by electronic means through WebEx. The meetings are also streamed on Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. For those participating virtually, when your item is called, you'll be unmuted by the moderator. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. People attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to a Toronto local appeal body or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies are permitted to appeal decisions. Today, I'll call each item in the order listed on the agenda. Where an application is contested, the agent or applicant will proceed with their presentation. When an application is uncontested, the committee may not require a presentation. The committee may ask questions and/or take the matter into committee for a decision. Any presentation or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept new materials at the hearing. The applicant or agent will proceed first and make a presentation to the committee. Then individuals either in support or opposed to the application will be invited to speak. Generally, we first call on speakers in the hearing room and then those participating through WebEx. Each speaker, including the applicant, will be given a maximum of 5 minutes to address the committee, and I'll comment when you're reaching the 5-minute mark. When all speakers are finished, the applicant or agent has an opportunity to rebut those issues that were raised by the speakers. This will mark the end of the discussion, and the application will be taken into committee for a decision. Are there any declarations of interest? Panel, Ryan, do you have an interest in which matter?
Number 23, Mr. Chair, 523 Delaware Avenue.
And the reason for the declaration is?
I have an esteemed colleague in the room who is opposing the proponent.
Okay. Any other declarations? Seeing none. Are there any deferral requests this afternoon?
Through you, Mr. Chair, see none.
Okay, and we can proceed. We will begin with item number 17. 2345 to 2347 Gerrard Street East. This is an application to obtain consent to sever the property into 2 residential lots and to maintain the existing easement right-of-way. Committee has before it a copy of the draft R plan of survey, copy of the plan of survey, 3 photographs of the subject property, and a covering letter from the agent. We have email correspondence from Community Planning, from Transportation Development Review, Metrolinx, and Bell Canada. And we also have a staff report from Engineering and Development Review.
Through you, Mr. Chair, we have a speaker in person for item number 17, the agent and homeowner. Please proceed to the speaker's chair.
Do I need to speak or?
Have a seat, sir, first. Have a seat.
Good afternoon.
Is your microphone on? Yep. Okay,
Hello.
I need your name and address for the record, sir.
Jerome Angeles at 95 Rushbrook Avenue in Toronto.
Okay. So you're just seeking,
Yes, I'm the applicant for the consent for separation or severance.
you're just getting a severance today?
Yes.
Okay. Do you want to just give us a quick overview of what you're proposing?
Yeah, our proposal is to sever the existing property into 2 triplexes with its own address, 2345 and 2347 Gerrard. One triplex would be owned by me and my family. The other would be my brother, Shane. We're both over 70 years old, and
We don't look it, sir.
thank you. It's the genes, I think. And the property is intended to be a family legacy. We're providing secure and stable housing for our children. We both have 3 children each, which is, with kids these days, they still need our support, especially here in Toronto. Given this advanced age, the severance provides the opportunity to transition ownership and management responsibility to our children. The 2 triplexes will be situated on separately managed lots, creating distinct living environments within the same property, potentially allowing for future multi-generational living arrangements. We believe this proposed severance will be compatible with the surrounding residential zoning and the general character of the Upper Beaches Malvern community. The proposal for 2 triplexes will maintain existing architectural harmony and will not negatively impact surrounding properties or the neighborhood's aesthetic. This actually is just a technical severance. We're not moving or we're not doing anything with the existing buildings. And
Okay,
that is it.
that's fine, sir. That sounds fairly straightforward.
Yes.
Any questions, Phil?
So just to clarify, right, the situation is, right now you own the 6plex together with your brother,
Correct.
and what you want to do is rationalize that so that you each own 1 triplex.
Yeah, sensibly and logically, of course.
Great, thanks.
Anyone else? Nope. Thank you very much, sir. All right, we're in committee. Looks like a straightforward application. Who wants to take this one? Katie, how about you?
It makes a lot of, pardon me, makes a lot of sense. Thanks for the background information on how this has come about. I will dive right into making a motion to approve the application to sever, including 1 condition from engineering.
Okay, motion to approve from Ms. Plaitzer, seconded by Mr. Ghosh. All in favor? You have your approval, sir. Thank you very much. You leave? You don't have to leave when the committee talks. I'm just concerned he didn't hear the decision, that's all. Okay. All right, we move on to item 18. This is 247 to 249 High Park Avenue. This is a application to obtain consent to sever the property into 2 residential lots and to construct a new 3-story semi-detached apartment building with a front and rear porches with stairs, front and rear basement walkouts, front, second, and 3rd-story balconies, and a rear exterior staircase that will lead to each level with balconies. Also to construct a rear 2-story detached ancillary building containing 2 garden suites, as well as 1 ancillary building, which is a storage shed with waste bins. There will be a total of 9 residential dwelling units on this lot, 7 in the semi-detached apartment building, and the 2 garden suites with the ancillary building. There will be 4 bicycle parking spaces and no vehicular parking spaces on this lot. Committee has before a copy of the minutes from the August 27th, 2025 hearing and the materials submitted. Copy of plan of survey, revised site plan, floor plans and elevations, copy of a draft R plan of survey, covering letter from the agent, an affidavit from another agent, covering letter from solicitor, and planning justification letter. We have staff reports from Urban Forestry. We have correspondence in support from Mr. Spoke, no address provided, 253 High Park Avenue, and 28 form letters in support signed by owners occupants of High Park Avenue, Dundas Street West, Annette Street, and Pinecrest Road. and also from 255 and 257 High Park Avenue. There is correspondence and interest concern from Mr. Martindale, no address provided, and from 315 High Park Avenue. Correspondence in opposition from 280, 245 High Park Avenue, 187 Annette. Mr. Webb, no address provided. 314, 237, 245 High Park Avenue. 245 High Park Avenue again through their solicitor. 280, 255, and 257 High Park Avenue. I'll note that 257 and 255 were originally in support, but I presume they've rescinded their support. Materials in opposition from 280 High Park Avenue, 245 High Park Avenue, and 187 Annette Street. Okay, do we have the agent?
Through you, Mr. Chair, we have the agent here in person. We have numerous registered speakers, both in person and online. So we'll start off with the agent.
Okay, thank you. Good afternoon. Is that microphone on? Or if you can get closer to it? Yeah.
Can you hear me now?
No.
Push the button. Can you hear me now?
Yes.
Before we start, there was also additional correspondence that was submitted by Urban Forestry. It was submitted yesterday, and our application coordinator noted that it was provided to the committee. So I just want to confirm that that correspondence was submitted, as it directly addresses and deals with the concerns that were initially raised in their
Is the
staff
Urban
report.
Forestry report, December 3rd?
No, there was additional correspondence that were supposed to be forwarded yesterday, December 9th.
Do we have it?
I do.
It's on the screen. We just received it yesterday.
Okay,
Okay,
so I'm going to get you to identify yourself and your address and your colleagues, and then you can, before your time starts, we can just understand what's in this.
Okay, great. So my name's Katrina Burgess-Mayo. I'm a legal counsel from Lupsha Nixon. My address is 130 Adelaide Street, Suite 2800 in Toronto, Ontario. I'm here with the applicant.
Okay, sir, you have to identify yourself and your address.
Ryan Valente, 144 Dover Court Road in
Okay.
Toronto.
All right, so let's just take a moment and see the forestry report before we start your presentation. So they're basically confirming that they have no problems with the variances,
That is correct.
and there are conditions.
That is correct.
Conditions two for each parcel.
Yes, correct.
Okay. All right, thank you. Okay, we have a lot of people who want to speak to this item, so we'll need a presentation.
Okay. So I'm appearing on behalf of the applicant, as noted, an Indigenous-led company whose aim is to provide affordable units within the city. The applicant has applied for a consent and 2 minor variance applications, which are to permit the development of a 3-story semi-detached building with 2 garden suites. The applicant has worked closely with the city staff and with neighbors to revise its application over the last 4 months, multiple times, decreasing the original variances that were sought from 20 for 249 and 16 for 247 to only 6 variances each. The main objective of the revisions was to address the neighbors' concerns. City staff is supportive of this application, including forestry, who we just noted provided revised correspondence as of yesterday. There are also a number of individuals who are here today to speak in support of this application, and as you mentioned, a lot of signed letters in support of this application as well. So the proposal will contain 9 units per address. It's going to replace the current unoccupied existing residential building whose interior is in significant disrepair and is not reasonably occupiable. This is demonstrated in my letter at page 46, where there's photos of the current interior. The proposal seeks to restore the building to a safe, functional residential use. It's located within an established low-rise neighborhood which already features a number of comparable multiplexes to the immediate north of the subject property and can be seen starting on page 35 of my letter. The surrounding neighborhood also includes walk-up apartments, garden suites, is within walking distance of many community services, is well serviced by public transit, located just outside of the High Park major transit station area. It has various bus routes nearby, including one that runs directly down High Park Avenue. The proposal is also being constructed through a CMHC program, which requires that more than 10% of the units to be below market rate rents, as defined by CMHC, for a period of 10 years or more. The proposal therefore provides affordable housing in a time when there is a housing affordability crisis, and seeks to increase the number of units available. The applicants are seeking consent to sever the property into 2 similarly sized lots with a mix of unit sizes and affordable housing. It's in keeping with the neighborhood's evolving and historical character and lot pattern. As detailed in the covering letter and planning justification letter, the consent application satisfies the Planning Act test, aligns with the PPS and the city's official plan. There were comments received that outlined the severance does not maintain the minimum lot size requirements, but I would like to note that Chapter 10 of the city's bylaw outlines that a semi-detached unit requires a minimum of 6 meters, whereas the applicant is providing 7.77, so well in excess of what's required. Next to the minor variance application, we submitted 2 letters. We would ask that they both be considered in your decision. We note that a zoning review was also completed by city staff for the application and only identified 6 variances required per lot. The minor variances that are being sought are minor in nature. They meet the intent and purpose of the official plan, zoning. They provide housing. They make the area more attainable. They make it more accessible. And they're desirable for the area as they meet the current character of the area. So they're applying for a variance to the building depth. This is only being done as they have enclosed the staircases at the front. This was at request of neighboring property owners, so they've had to now apply for this variance. It'll facilitate the development of livable units by increasing the depth, and it's comparable to other applications that have been approved in the immediate vicinity, including 220 and 332. High Park. The design results in a proposal that's in keeping with the neighborhood and surrounding buildings, including the development the property that's located to the immediate south, which is depicted in photo 49 of my letter. The applicant is also seeking an increased FSI to facilitate the construction of family-sized and accessible units. This is comparable to other developments that have been approved in the area, including 319 High Park and 332 High Park. It meets the test because impacts are mitigated by height, the angular plane, and the rear yard depth that they are seeking. They are also seeking soft landscaping changes. They're to provide access to the garden suites. The paths will be constructed with permeable pavers, and we'll have a strip of soft landscaping to the side to allow for buffering and appropriate separation. This was done in response to city staff's comments. They have also are seeking a variance to permit 2 units within each of the detached garden suites. These units have been approved by, 2 units have been approved in garden suites by the city and by this committee. Concerns relating to the garden suites that have been raised by the neighbors are in relation to the fact that it's 2 stories, and this is permitted as of right per bylaw 849/2025, which was approved this year in July. This variance is simply to allow for 2 suites, which would directly increase the number of affordable units required. May I conclude? It will only be a minute.
Yes, please.
So I'll address other concerns such as parking, bike racks, etc. in my resubmission at the end. But the applicant has spent over 4 months revising this application to satisfy the city's requirements as many concerns from the neighbors as reasonably practical. The revised application is a product of those discussions. The application meets the test for the statutory test for consent and minor variance applications and provided much needed affordable housing within the city.
Thank you, ma'am. So you were deferred previously, and as part of the deferral, you were gonna revise your application, but it was also gonna consult with the neighbors. Did you consult with the neighbors? Just for
Yes.
the record,
They
the
consulted
applicant
with
is
the
nodding
neighbors.
yes?
Yeah, we did.
Okay.
We did multiple times. And we
Okay.
included an affidavit of when we spoke with all of the neighbors
Yes,
as
I
well.
saw that, yeah. Okay, great, thank you. Now, we've got a lot of speakers, but we want to hold questions until after we hear from them. Can I see a show of hands? You said there's people in support. Who's in support of this application that's here today? Okay, who's opposed? Okay, with your indulgence, I'm just gonna do this in an orderly fashion. We'll deal with the support first, and then we'll deal with the opposed. Is that okay with everyone? Okay, why don't we do that? So I'll ask the first supporter to come up, please.
One at a time. Who's in support, come to the podium.
Hi, name and address, please, sir.
Good afternoon. My name is Jim Ilkay at 10 Innisfree Court in Toronto.
Okay. You have 5 minutes.
Okay, thank you. I support the application for a number of reasons. First of all, I mean, building housing, when it's difficult to build housing right now, so building housing at this time is a very positive thing. This area is intensifying, we can see that. The question is, how is it going to intensify? And this proposal, and I've seen a lot of proposals, this proposal really fits well with the neighborhood. The units are quite livable. I think the plan is well designed and well thought out. The variances, one thing I will say is that if you looked at the initial application, and I'm not intimately familiar with the application, though I did read all the material that was available, it looks like there were quite a number of variances and effort was made, as you'd want to see, to work with the city and work with the community to get those variances down and to get closer to the prescribed, I guess, the parameters in the bylaws. Overall, I think the application represents good built form. It fits well with the neighborhood. It looks like a high-quality building that people would want to live in. And this area is very well served by transit. You know, we're within walking distance of 2 subway stations. We've got the streetcar on Dundas, lots of amenities, and you want people moving into areas like this. The alternative, I think, and what I worry about sometimes, is we'll end up seeing taller buildings or 6-story buildings or things like that to get even more people into these areas, which I'm not suggesting is necessarily a bad thing. I just feel like this would probably be a preferred alternative to that. So for those reasons, I support the application, and I think it makes good sense.
Okay, thank you, sir. Panel, any questions of the speaker?
Sorry, I just hadn't caught your address, but maybe you can, the question I have is, you live in proximity to this location?
I do, yeah, and I have a property also that's close, like I live at 10 Innisfree, but I have a property at 1830 Bloor, which is just around the corner.
Okay, great, thanks.
Thank you, sir. All right, next up. Hi.
How are you?
Name and address, please, ma'am.
Caroline Hodson, and I live at 1171 Queen Street West,
Okay,
apartment 107.
over to you.
I am in support of the building because this has been my dream neighborhood since I moved to Toronto, but at this point, moving there, I feel like the only options are houses, and that's just not really in my price range. I also love the neighborhood because I have a bunch of family and friends that live there, so it's kind of been a destination for a while for myself. But a friend of mine lived in one of their buildings on Dover Court, and it was just, it's one of those, like it fits in with the street, and it's a multiplex as well, really safe, like, it feels nicer than anything else that I could afford, really. And I love that they're doing it in like my dream neighborhood. So when she had mentioned that this company was going to do another building, I just got excited to see what it would look like, because I feel like they take so much thought into what the neighborhood should feel like. Both neighborhoods, Dover Court and this one, it feels really nice to live there as like a young woman. It feels safe. At the High Park address, there's Dundas West, where I walk around with my friends at High Park. It's just, it feels like a nice part of the neighborhood you want to live in. And if there's affordable housing for people my age, I feel like it would bring a whole bunch more women into the neighborhood, which would be amazing. My sister lives close by, my friends. Yeah, oh, I love that they also went into like what the neighbors thought too. I know that the stairs were originally supposed to be outside. I heard you guys talk about it earlier too. And I really appreciate that they take in the neighborhood. It's just very thoughtfully created and designed.
Great. All right, thank you very much.
Thanks.
Panel, any questions of the speaker? See none?
Thank you.
Thank you very much. Hi.
Hello. My name is Joe Giancarelli. I'm at 70 High Park Avenue.
Okay. All right, sir. Off you go.
The people ahead of me actually
They stole your thunder?
mentioned a little bit. But I'm also in support of that for, I think, a couple of key reasons. First of all, I think it's in keeping with the neighborhood. I know that it's a desirable place to live. And from the street, it certainly looks to be appropriate. It doesn't look like an apartment building. A few other notes. I think it's a gentle and thoughtful intensification for the street, so I'm supportive of it. One of the reasons I'm also supportive is I know that The owners has spent a number of months consulting with various neighbors and tried to modify their application to ensure that everyone is pleased as they can be. I know that not everybody wants to see change, but I think it's inevitable. And I think this is part of the city's mandate to ensure that there's increased density around public transit. And having lived there, I think allowing more people the opportunity to enjoy all the amenities that are there, whether it's park, such as High Park, or the walkability of the area, I think that's important. For those reasons, I'm very much in support of this application.
Great.
So I'll
Thank
keep
you
it
ver-
quick, because I know there are a
Thank
lot.
you, sir.
Thank you so much.
Any questions of the speaker? None?
No.
Thank you very much,
Thank
sir.
you.
Thank you.
Next, from the support group, anyone left? Oh, okay. Then maybe we can go to those that are opposed. Whoever wants to come up first. Hi, good afternoon.
Good afternoon.
Name and address, please, ma'am.
Is it working? Okay. My name is Gina.
You can pull it a little closer to you, yes.
My name is Gina Kindry, and I reside at 187 Annette Street.
Okay. You have 5 minutes, ma'am.
Okay. I object to the proposed development of the two-story garden suite at the south end of my property line. I am the owner of 187 Annette, a home that has been in my family for 75 years, purchased by my grandfather in 1950. I have moved back to my childhood home 9 years ago, following my mother's death, to enjoy my retirement years. I have serious concerns regarding the irreversible impacts this proposal will have on my property value, enjoyment of my yard, and the character of our neighborhood, and the mature natural environment that currently defines this area. The number one point is the destruction of mature trees and loss of urban canopy. The proposal requires cutting down 2 of my mature trees, 11 meters high and 13 meters, and threatens multiple others that form the immediate horizon at the back of my property. They want to remove every tree surrounding their property, with a total of 6. These trees are integral to the neighborhood's natural landscape and contribute significantly to Toronto's urban canopy. Once removed, they cannot be replaced in any meaningful time frame. The second point is the significant impact on the heritage garden features. My backyard includes a long-established secret garden that is widely regarded by visitors as an unexpected and uniquely private green space, an irreplaceable feature that adds substantial character and value to my home. The garden includes 50-year-old raspberry bushes planted by my grandmother, which will be deprived of sunlight due to the height and placement of these proposed 2-story structures. Instead of a beautiful view of trees, I would now have a 2-story monolith of a wall to look at. This is not simply landscaping, it is a living part of my family history. The third point is loss of privacy and neighborhood character. The proposed building's height and massing are incompatible with the existing backyard context. A 2-story structure at the rear lot line would eliminate the privacy that my property has maintained for generations and would dramatically change the park-like character of the block. In addition, the proximity of the garbage shed right at the southwest property line would result in continual traffic and possibly odors. The development would introduce significant overlook into my yard and diminish the quiet retreat that has defined this neighborhood's rear lane environment. Number 4 is the negative impact on my property value. I have included my real estate agent's letter in my attachment. The exceptional privacy and unobstructed natural views provided by my backyard have been repeatedly noted by visitors and real estate professionals as a key selling feature of my home. The proposed development would materially reduce both the character and market value of my property through loss of sunlight, tree canopy, and backyard privacy. Fifth point is concerns regarding overdevelopment precedent. Approving a 2-story garden suite of this scale, which is basically a 4-plex on the south end of my property, sets a precedent for oversized rear yard structures and contradicts the intent of garden suite policies, which are meant to allow gentle density, not rear yard intensification that overwhelms neighboring lots or destroys mature natural features. 6th point I want to make is clarification, read the petition I signed. In the summer, my husband and I were in the garden. We were surprised by an unannounced visit by 2 men who we thought were the new owners. They mentioned a 1-story garden suite and cutting part of my large tree and promised a privacy fence and new replacement plantings. We signed their initial petition, feeling a bit pressured without reviewing their plans. We now do not want our names on that petition. It's come to my attention that similar pressure to sign this petition has been experienced by others in the neighborhood. I respectfully request that the city deny this application in its current form. At minimum, I request that no approval be granted until mature trees are fully protected and preserved. The height, massing, and placement of this proposed garden suite be reduced to 1 story, and the garbage shed be moved away sufficiently from my southwest property line such that my privacy is protected. Thank you very much.
Thank you, ma'am. Just a point of clarification, I think on your first point, you said, I thought I heard, that they're planning to take down your trees on your property?
Yes, I have the pictures of those trees, image 1 and 2.
Okay, that's fine. I just needed to clarify that, so
Yeah, that's my
we'll
garden.
ask the agent that question about
Right.
that tree.
Okay.
Thank you. Sorry, one more question?
Just very quickly, you back onto the rear of one of the lots, is that right?
Yes, the south end of my property is their north.
Oh, I see, okay.
See, that's my yard.
Yeah. Yeah, so it's a unique shaped,
Yeah.
yeah,
The
okay.
south end of my lot backs onto where they're
Got it.
going to build it.
Thank you.
Okay, thank you, ma'am. All right, who's next? Good afternoon.
Good afternoon, sir.
Name and address, please.
My name is John Sutton. I live at 215 Hyde Park Avenue.
Okay, you have 5 minutes, sir.
I want to thank you all for the job that you have to do in this. Our job as neighbours in looking at this is made more difficult when late submissions, like the lawyer's letter that came in at 11 o'clock on the following day, so nobody has any chance to look at the conditions in it. For the first time, we find out that this development is subject to certain CMHC lending requirements. It's now Indigenous-led. I find that the application process has been very difficult to deal with. The original application filed in April had at least 3 false declarations in it, one related to the trees. It was absolutely no false declaration. Now they come and say, oh yeah, there are 6 trees that are going to be taken away. We haven't seen the city forestry department review. The second declaration was the removal of rental suites. They totally ignored that issue. And they also ignored the issue of, hang on, got to make sure I get them. Yes, it was the trees, the tree declaration, and the rental housing removal. All of those 3 things in the original application were false declarations. So the neighbours are put in a difficult position. We are looking at the zoning in this area is 0.6 FSI. They are looking for 1.35, and they say, oh, you know, that's okay, we're doing it in 2 stories. They're looking for additional depth, and then they take a percentage of that depth and say, that's softscape. Well, their softscape does not include any pathways for getting out of the basements in either the front or the back, and in the back, they're the only entrances and exits to those suites, or the 2nd and 3rd floor units at the back are shown terminating in soft landscape. So it cannot be built that way. People in Toronto are not going to live in apartments where leaving their apartment they have to trudge through snow or mud, because that's what it will end up being. So I find that the The process has been difficult, and everybody's lauding, quotes, the neighbourhood outreach. They've got umpteen letters, 30-plus letters, but you notice that some people have withdrawn their support because they suddenly realised that they were misled in what they were shown. I am mentioned in the, quotes, affidavit as the meeting with me twice. Both the time and the nature of the interactions with me are misrepresented in the affidavit, and I believe that the affidavit itself has to be completely ignored because in Ontario it's an obligation of the Commissioner of Oaths not to have a conflict of interest. Well, the man who has signed it as Commissioner of Oaths, and he's a lawyer in Ontario, is in fact one of the principals of this development, and he met me with Ryan, who made the affidavit. The affidavit is complete garbage. It's rendered void by the fact that the conflict of interest of the Commissioner of Oaths, and as a lawyer he should know better. So as a committee, you've got an awesome responsibility. As neighbours, you're our last line of defence for something that's clearly too large. As the Gasparis decision in 2005 stated, sometimes things are just too large. For every square metre of depth, they're removing 1.5 square metres of softscape. The softscape is misrepresented because of the lack of access pathways. So I commiserate with you that you have to make decisions based on stuff that over many, many months they haven't been able to clear out. And there's some of the things, the pathways on either side of the property, they're shown at 0.9. They have to be a minimum of 1 metre, and that cannot be adjusted by a committee of adjustment. The garden suite regulations state that. I'm sorry if I get emotional on this.
No, that's okay, sir. Your time is up.
I appreciate that, sir.
I do have a couple of points. So the second of your points had to do with the removal of rental accommodation. I'm not sure I quite understood that point.
Any building of 6 or more units being removed from the housing stock in Toronto.
Oh, so you're saying what's there right now?
They declared it wasn't ever rental property, basically.
Okay, that's fine. I just wanted to understand what you meant by that. Thank
Yes,
you for
sir.
that. And I do know you live a few houses down. I appreciate your concerns about the impact on the neighborhood broadly and such, and its size and scale and scope. Is there a direct impact on you and your home?
Well, to some extent, yes, because there's no enforcement. The Committee of Adjustment has no mechanism to enforce their decisions, and that is evidenced by 220 High Park Avenue across the street and 213 right next door to me. 220 have not closed out their permit. They clearly have virtually zero soft landscaping, but because they'll never need to sell. And next door, same thing, Committee of Adjustment, 50% landscaping. It's less than 25%.
All right, the only thing I can say to you, sir, is that in order to close a building permit, they have to satisfy any Committee of Adjustment conditions. So they would not be able to close that permit until they've met that.
And at 225, they failed to get Committee of Adjustment pre-approval. They came back after the fact, and of course, it was built and they got it.
I understand, sir.
That's the problem, part of the problem.
Thank you very much, sir.
Thank you.
Any questions of the speaker? Thank you very much, sir.
Thank you.
All right, our next speaker. Hi.
Hi.
Name and address, please, sir.
Noah Waters, at Noah like the Ark. Address 245 High Park Avenue, the building right to the south of the property in question.
Great. You have 5 minutes, sir.
Thank you. If you look for the blue colored slide deck, that's me. I'll try and get through it quickly. I have some concerns about a couple of variances to concern the bike parking and other vehicle parking. So a little bit about me. So I don't own a car. I do own a bike. I've lived in Toronto since 2018. The main issue I have, sorry for my notes here, the units that they're going to put in is, for the whole lot, would be 18 units, I think 32 bedrooms or something like that. The proposal is to put in 8 bike racks that are stacked, and they're also below grade. You have to walk downstairs to get to them. In my experience, that's not a very good storage solution for bikes, and if I was a tenant looking for an apartment, in my situation, I would not want to live there. This is also just not enough bike racks for, guests, because if you have guests, they're going to need to park their bikes. Also, High Park Avenue has no post and rings on it, so there's no place for anybody else to park bikes on it. And because it's a boulevard street with a soft landscaping next to the sidewalk, I don't think there would be any place to put post and rings. So the other point I have is about the car parking allowance. So I think it's not including any parking at all. Now, I don't fundamentally think that we should be putting parking in every building that's built in Toronto. Certainly not at a 1-to-1 ratio, but this does affect me somewhat because just the sheer number of units that they're putting in that would potentially add a lot of car parking on the street. And I use car share. It's a Caminado floating cars. If you look in the slide deck, you can see when they're available. There's kind of a pattern to where they get put. They often get bunched up around the big apartment buildings that are down at the south end of the street. That's because they have big parking garages. Now, because these cars in the floating pilot program, they compete on the open market, as it were, for street parking permits. You have to store them on the street. So if you're adding this many units, if they all use Caminado, that's great. If they all buy cars, that adds a non-consequential number of cars that might be available, because it could be everybody, could be nobody. And the Caminado program is also a pilot program in the city, and I'm kind of concerned, my friends are a little bit, think I'm catastrophizing here, but there's nothing to prevent the province from stepping in if they get enough complaints about this pilot program. Like, we can't have, the residential permit holders aren't having enough room to park, so we have to kick out Caminado, which means more people have to buy cars. And also I can attest, as I use TTC, the bus route that does run on High Park Avenue, it's been changed. It's actually back-to-back with another bus route, which sometimes makes it unreliable. So my main concern is this, like, an inadequate number of bike parking spots. There's a lot of people who are using cargo bikes for their families now in the city, and putting the bike storage downstairs and stacked, it's just completely incompatible with cargo bikes. You just can't get them down. I mean, it's theoretically possible, but it's not advisable. And I believe this was actually a reduction in the number of bike parking spots that was suggested because they had problems with getting bikes back to the storage sheds in a previous design. So they've reduced it and they put them in the front downstairs. So that's my main points.
All right, sir, thank you very much. Any questions, ma'am? See none. Thank you very much, sir. All right, anyone else in the room that's speaking in opposition? Yes. Oh, there you are. I noticed you were sitting on the support side.
The house shall divide.
Sorry, we can't see any boards.
No, if you can hear me for 2 seconds. The reason I brought this is actually the developer's building, but they've shown it completely out of context, and I just wanted to bring some clarity by.
I'm sorry, these materials should have been submitted at the time of the hearing, before the hearing, so that we could present it on the screen and everybody can see it at the same time.
Yeah, I apologize, sir. Those are our rules of procedure,
Nope,
and
that's
they're
fine.
there for a good reason. Maybe you can just speak to the issue you wanted to illustrate. Your name and address, please.
Sure. My name is Andrew Marchenko, and I live at 280 High Park Avenue.
Sir, you have 5 minutes.
All right. Dear committee members, I'm here to express my extreme disappointment with the design for the 18-unit building being proposed for 247 and 249 Hyde Park Avenue. In short, through the Committee of Adjustment process, the developer is asking us to compromise to accommodate them into the neighborhood for our support and for you to allow a development proposal that is larger, taller, longer, wider, and not a character to the neighborhood. You have heard from neighbors adjacent to the subject property and heard how this proposal adversely affects them. Since 1993, my family and I live at 280 Hyde Park Avenue, so we're not going to be immediately impacted by this. But I completely support their objections. I'm going to speak on how this proposal affects the street and the neighborhood. The very nature of compromise is that the developer gives something back to the neighbors and neighborhood. There is nothing in the proposed development scheme that does so. To immediate neighbors, in the least, privacy is diminished, view and light are blocked, parking is thinned, and the enjoyment of the backyards is removed. To the neighborhood, this blight of a building reduces the walkability and enjoyment of the street. We moved here and to continue to live here due to the beautiful character of the street, as well as all the cultural, social, and recreational amenities that are embedded in this walkable neighborhood. The City of Toronto recognizes that Toronto is known for its numerous neighborhoods and the strength and diversity of those neighborhoods. The City of Toronto actively works to maintain the character of its diverse neighborhoods through its official plan, which establishes policies for new developments to be contextual sensitive to the area's historic pattern and defining features, such as street layouts, lot sizes, and building materials. Oh, geez, my computer's acting up. Oh, yes. Toronto's successful neighborhoods are all characterized by having multiple public destinations, shopping, recreational, cultural, and social amenities that are connected by safe, engaging, and pedestrian-friendly streets that themselves become preeminent public spaces. It is this armature of destinations and streets that form the armature on which community is based and what allows those neighborhoods to strengthen. So to contrast what we have in the city compared to subdivisions, in subdivisions, they are buildings that are set apart. The streetscape itself is such that it's not enjoyable to walk on, and so eventually the developer is able to prove that nobody walks. So sidewalks are taken out, which then becomes dangerous to walk on the street. And so for you to meet a neighbor on the street, incidentally, that's removed. Kids aren't allowed to bike or walk on the street, on the street itself. So the whole character of the neighborhood changes. What differentiates Hyde Park in most cities in Toronto is that character is the city worked hard to maintain it, and the neighbors, through their own stewardship, have worked hard to maintain the character. So Hyde Park's unique character derives from a historic tree-lined street, which is defined mostly by Victorian, Tudor, Craftsman, Edwardian single and multifamily homes, which were complemented by the missing middle housing styles like townhomes and semis, creating a diverse community alongside the neighborhood's natural areas, including Hyde Park itself. The area blends urban convenience of transit and shops along Annette and Dundas Street, but this only works if the neighborhood stays walkable. The outdoor room of Hyde Park is defined by the width of the street, the tree planting strips between the sidewalk and the street, the setback, massing, style, setback, and scale of the homes, the predominance of porches and materials and height of individual houses, which all combine to create an engaging place within which to walk. Diminishing this character by allowing individual properties to no longer adhere to existing character will eventually weaken this character, akin to a beautiful smile being ruined by missing teeth. Although ours is a single-family home, we, along with many of our neighbors, are not in objection to the provision of multifamily housing. There are numerous local examples of how this can be done, but in a way that fits in the neighborhood. The building immediately to our south at 276, 278 Hyde Park Avenue also spans 2 lots, has 8 units, but fits into the neighborhood by respecting the size, massing, and style of material of the buildings around it. The Committee of Adjustment is a venue in which the developer presents his proposal to the city, and then the opinions of the neighbors and neighborhood are heard and addressed. We are being asked, oh dear, let me just span ahead because I just noticed the time. The building owner of this proposal will capitalize on the strength and character of the neighborhood by charging the higher rents this area supports at a cost to be borne by his neighbors and neighborhood. as doing so will diminish the privacy value and enjoyment to those neighbors and diminish the value and enjoyment of High Park for our neighborhood. To build something that is completely ignores the neighbors and neighborhood is selfish and should not be acceptable. For the above reasons, I object.
Great, thank you very much, sir.
Thank you for
Any
hearing me out.
questions? See none, thank you very much for coming.
Could I just make a,
Yeah, your time's
for-
kind of up, sir.
the frustration for me with this is we expected and I asked for show the building in context. So for the proponent to walk and then letters to be sent that people actually get what they're building without showing what's building beside that shouldn't be acceptable.
Okay, we understand your point, thank you.
Thank you.
All right, anyone else in the room wishing to speak on this item? Okay, see none, is there folks online? All right.
Through you, Mr. Chair, we'll start with the online registered speakers. First up will be Grace O'Brien. Hi, good afternoon, Grace. You've been unmuted.
Good afternoon,
Hi,
Mr.
ma'am.
Chair and panel.
Just speak up a little louder if you would, please, and give us your name and address.
Perfect. Is that better?
Sure.
My name's Grace O'Brien, and I'm a lawyer with Davies Howe, and we're located at 425 Adelaide Street West.
All right, ma'am, you have 5 minutes.
Okay. So I'm counsel to Lorinda Mazza and David Webb, who are the neighboring landowners to the south of the applicants at 245 High Park. So we're requesting the committee to refuse the consent in both minor variance applications. I filed written submissions, which are on the screen, on December 3rd, that detail why the applications, both individually and collectively, do not meet the Planning Act tests. And rather than repeating those submissions, I'm going to speak to the impact the proposed development will have on my clients and to some of the points raised by the applicant in my friend's submissions. So we agree that High Park is an excellent neighborhood with many amenities, and that the neighborhood can and should find opportunities to provide missing middle housing. But this objective should not be achieved at the cost of good planning. I'd ask the committee to look at the proposal before it and question whether the property can realistically accommodate this development without significantly impacting its immediate neighbors and those within the community, some of whom you've heard from today. So if you go to page 18 of my submissions, you can see renderings prepared by my client's architect of what is being proposed. Essentially, you can see here that the applicant is trying to squeeze too much onto the site without considering how it will impact the site's functionality and its neighbors. The requested consent and both variances will result in a significant increase in the use of the property from 6 units to 18 units, and is not modest or gradual intensification, but rather an overdevelopment that cannot be accommodated on this site. So you heard from the applicant that it made various changes to the proposal to reduce the amount of variances sought, but none of those revisions actually address my client's primary concerns with the proposal, being the overall massing and density, the external rear staircases combined with the depth of the buildings, the 2-unit garden suites, and the impacts that it will have on the boundary trees and my client's butternut tree, which is 5.4 meters from the property line, and it's protected under the Endangered Species Act. So for the proposed depths, the applicant is seeking depth variances of 24.92 meters, which are almost 6 meters more than what the zoning bylaw permits. The applicant justified these depths by saying that it was required to accommodate the internalized front stairs. But my client's concerns, as expressed to the applicant, are primarily with the rear external staircases, which were not internalized. So this leaves my clients with not only a longer building that extends well past the rear of their dwelling and their second-story deck, but also external rear staircases that protrude even farther out. The users of the proposed development's balconies will be able to look directly onto my client's second-story deck and over the garage into their backyard. And I appreciate that some level of overview is common in urban environments, but the impact that these depth variances will have on my clients is well beyond what is common in the neighborhood. And similarly, when the proposed FSI variances of 1.32 and 1.35 times the lot areas are considered with the proposed depths, the 2 sheds, the 2 two-story, 2-unit garden suites, and the decreased landscaping, this exacerbates the impact of the building on its neighbors, and it results in a huge building next door that has no regard for the size of the site. And in relation to the proposed 2-unit garden suites, no 2-unit garden suites have been approved within 500 meters of the site. None of the examples provided by the applicant are within 500 meters, and 2 of them are for laneway suites, which present different circumstances because they don't take up as much of the site's backyard and reduce the landscaping and can be accessed from the laneway. In this case, the proposed 2-unit, 2-story garden suites result in overcrowding the site, and they decrease the urban canopy and landscaping on the site, particularly when this is combined with the 2 7-unit apartment buildings. So to summarize, the consent application and the minor variances do not meet the Planning Act tests. The variances sought are not minor in number, and they're also not minor in the impacts that they will have on my clients and the neighborhood, as you heard today. The proposed development is trying to squish too much on too small a site at the expense of the rest of the neighborhood. And that's why we're requesting the committee to refuse the applications. Thank you for your time today.
Thank you, ma'am. Panel, any questions of the speaker? None? All right, thank you. Nick?
There's a speaker online that has to leave at 3:30. Is it possible for them to go next?
Oh, yeah, sure. I didn't really separate the supports out from the opposers, so.
He just has a personal commitment for a doctor's appointment or a meeting. I'm not quite sure, but he can't be here past.
What's the name?
Matt Hyland.
Have we got him online? Yep, can we unmute him?
Thank you so much.
Do you have any questions for this past speaker?
Oh, did I ask that? I thought I asked that already.
No.
Good afternoon, Matthew Highland. You've been unmuted.
Hi, thank you for hearing my position.
Okay, sir, just your name and address, please.
Matthew Highland, 62 Cliveden Avenue.
All right.
He's online, yeah.
So this is a neighborhood I know fairly well, having relatives in the area, and they've kind of, they've been there since the early 90s. They believe that there's been kind of increased densification in the neighborhood through that whole period of time. If it's done thoughtfully in a way that's in keeping with the neighborhood, as I believe this proposal is, they welcome it, and we all do. I think, in this case, there are, many efforts that have been made on behalf of the developers to improve the scope of the development to be compatible with the neighborhood, while also adding density. It is a very accessible, part of the neighborhood, connected by transit. I use the TTC when I visit the subway to visit my relatives, my aunt and uncle specifically. And it also adds, more entry-level rental units to the neighborhood that, are really scarce today. And so I think it kind of provides that community benefit. It's in keeping with the neighborhood. It's what the city and the province are asking for, adding density to neighborhoods in a way that is compatible, or as compatible as it can be. No matter what, when you add density, it is not going to be like what was there before. I think, what was there is there before in this case is underutilized and not functioning as its intended purpose. It's a building that was built probably 50 years ago, I believe tenanted in the way that the neighborhood, warrants. So, I just think, this is a way to, this proposal or one like it improves the site, it improves the neighborhood, it improves livability for residents in the city and in the West End in general. And, those are just kind of my beliefs. And yeah, that's it.
All right, sir, thank you. Panel, any questions of the speaker? None. Okay, thank you. I don't know, is it possible just to do the supporters then the opposition, or are we just going through in order? Doesn't matter.
Through you, Mr. Chair, we don't know exactly who's here in support and opposition, because sometimes when people register, they don't actually state it. So
fine.
that's why we're
we'll
not
just
able to do
these
that.
speakers in order then.
Yeah.
Okay, thanks. All right, our next speaker?
Through you, Mr. Chair, we have William Francis up next.
Mr. Francis.
Hopefully everyone can hear me.
You can. Name and address for the record, please, sir.
William Francis, 20 Gothic Avenue.
All right, you have 5 minutes.
Yes, thank you. So I live relatively close, right by High Park Station. I'm here because I believe that Toronto needs to continue growing in a responsible and thoughtful way. I believe the demand for high quality rental housing is outpacing the supply in our area, and that developments like this one proposed are important if we want to keep the city as attractive as possible for both current and future generations. The site plan seems like a great opportunity in the West End for some gentle intensification. It steps from transit, it's close to High Park Station, it's walkable to both Bloor and Dundas, and sits within a neighborhood that already has a mix of homes, multiplexes, and mid-sized buildings. I think the idea that this street cannot accommodate a modest increase in housing with a nice new build doesn't really reflect what is already here or what I believe the city encourages and should encourage. I believe this proposal is balanced. It introduces new rental housing without overwhelming the street. It's just 3 stories. It looks like 2 superb new semis while offering livable units, not the micro units. I believe there's no studios without windows, but rather real living space that people can enjoy and grow into. There's different bedroom unit sizes with their own entrances, and there's outdoor space. And I think that that level of new rental construction is exactly the kind of housing Toronto lacks and would benefit our area. The lot itself is obviously large, and in compared to the lots in the neighborhood, and I believe the footprint appears modest. I believe a large percent of the property is being kept as a green space, and that some units even have private yards. I think that would be amazing rental supply compared to the micro units often built and available today. We talk so often about the housing affordability crisis in Toronto, and I think this appears as a real contribution to the area, and actual accessible and affordable units that will also make the neighborhood look more attractive with a new build compared to the current vacant building. I believe there has been a demonstrated willingness to listen and adjust and cooperate on variances through working with the city and neighbors. I think this shows respect for the neighborhood and that there's a genuine desire to contribute positively rather than impose something rigid. So I don't think Toronto or this area should say no to appropriate, well-considered kind of mid-scale rental housing like this, especially in transit accessible areas. We need places for everybody, young people, newcomers, families, long-term residents to be in this community and in communities that they love and can grow into. I think if we want a city that remains dynamic and inclusive, that these are the kind of projects we should be supporting. So I think this proposal is thoughtful. I think it would be a nice addition to the High Park area and High Park Avenue. I think it obviously adds rental housing. I think it respects the character of the street and would benefit the area. I think this is the type of growth Toronto needs in order to remain a city that people can and want to live in and can afford to live in and have more rental options available. So thank you for your time, and I sincerely hope that you will support and consider the severance and variances.
Thank you, sir. Panel, any questions of the speaker? None? All right, thank you very much, sir. Next speaker?
Thank you.
Through you, Mr. Chair, we have Sharon Venin next.
Hello, Sharon.
Hello, good afternoon. Thank you, members of the committee. My name is Sharon Bannon. I live at 245 High Park Avenue. This is the adjacent property to the south of the proposals. I have already submitted 2 emails in opposition to the proposals, one on August 18th and the second one on November 26th. I will quickly reiterate the content of those emails. I reiterate what other objectors have said about the variances being neither minor in number nor impact. I'm greatly concerned that this proposal is being passed off as increasing accessibility. As you can see from the renderings, from the models, this is an extremely inaccessible project. These stairs alone, I cannot imagine how treacherous that would be for anyone with any kind of physical mobility issues, anyone with a walker, a wheelchair. It would be impossible. I cannot imagine how difficult it would be for somebody with a pet or young children, a pregnant woman, especially in the winter. It's an abomination. I have already outlined in my previous submissions that there's too much density for the space. We've been hearing that over and over this afternoon. I'm particularly concerned about the removal of the driveway that exists in between the houses. That will be reduced to a single laneway that is a mere 1.2 meters wide. Again, that greatly restricts mobility. It restricts accessibility. My home office is on the first floor that overlooks that laneway. My bedroom overlooks that laneway on the first floor. I am concerned about noise that will disrupt me during the day while I am working, during the night when I am sleeping, not to mention the sounds of footsteps on those metal stairs that have no enclosure to buffer sound. There are also no parking spaces, which is in contravention of bylaw 569. There are 0, there's a minimum requirement, and so it is completely unrealistic to have this much density and 0 parking spaces. There is also insufficient bike storage space. One of the highlights of the High Park neighborhood is how beautiful it is, how nice it is to have a bike in this neighborhood, and the proposal does not permit that. It's completely unrealistic. I've also mentioned that the increase of the depth is far too insufficient to even accommodate fire department hoses. So this is a health and safety hazard. I'm particularly concerned as well about the loss of trees and the old standing flora, the raspberry bushes, the loss of beauty, which is so unique to the High Park area. This will decrease the privacy of the existing homes in the area, including the home in which I live. There is a lovely backyard, and that was one of the highlights for me to want to live in this house. I will no longer have that to the same extent because of the encroachment of these monstrosities that are going to be built in the back, as well as the tall new structure that's proposed. So that also affects the residents of the proposal. They now will they will not have any livable outside space because the majority of it will be taken up by trying to cram in as much housing into a tiny lot. Right now, there is a garden, and the previous residents had a beautiful garden that they would enjoy. That is no longer, and that's a loss to the neighborhood. I am also questioning the integrity of the applicant. They submitted an affidavit on December 3rd that says they have done extensive neighborhood consultation. I am in the next door house and I have not been consulted. The affidavit of Ryan Valente claims he made efforts to consult the neighbor. He does not outline how he tried to consult the neighbors. He simply says that he did, but there is no evidence. He did not attempt to do this in writing. I did not receive any written documentation from him that he genuinely wants to consult with the neighbors. It was a very amateurish approach at best, if it even happened. I also will point out that we have heard from many supporters who I do not believe actually were given the models or given any of the plans. They made support without knowing the full details of this proposal, and had they seen the details, they likely would not be in support. So I believe that some of the consultation efforts were not made in good faith, and so the committee has to question the validity and the reliability of Mr. Valente's affidavit. And I will also note that his so-called efforts to consult the neighbors happened after somebody like me submitted my objection. So it happened too late in the game. A genuine concerted effort to consult with the neighbors would have happened at the earliest stage, and that did not happen.
Ma'am,
And
I'm just going to ask you to wrap up, please.
that's fine. That concludes my submissions. Thank you.
All right, thank you, Mayor. Panel, any questions of the speaker? None? All right, we can get our next speaker.
Through you, Mr. Chair, we have next up Anne. Hi, Anne, you've been unmuted.
Hello?
Hi.
Hello, am I unmuted?
You are. If you could just speak up a little, please.
Yes, my name is Ann Pick and I live at 314 High Park Avenue, half a block north of the properties in question. We've lived here for over 30 years and have seen and participated in the amazing revival of the junction from a depressed community to a thriving community. We and our neighbors are not opposed to development, but stand firm that this should be done with appropriate design and open civil consultation to exchange points of view. This has not happened. The now owner developers, Reside Properties, have been unwilling to consider the negative impact the development will have on its neighbors due to height and length, and begrudgingly made changes that in the end made the building even bigger, still with a long list of major bylaw violations. They could have reduced the number of units, not increased the length. They have resisted any suggestion that they might instead renovate and extend the old sixplex, which the city calls reuse and recycle and encourages. They insist they have the right to build many apartments as they want because it's the only way they can make a profit. Perhaps they made a bad real estate deal, but their financial viability is not our concern, nor should it be the committee's. They also have a bad plan, pushing the bylaws way past the minor considerations that the COA is tasked to adjudicate. Too high, too long, massive semis with very little green space between them and the bin shed and the 2 garden suites per half, which completely block the light and view of surrounding houses. Some variances have been raised, but here are a couple more. The 3rd floor is called a family unit with 3 bedrooms, but there's no storage other than bedroom closets in the apartment or in the auxiliary buildings. Believe me, a family of 3 or 4 has stuff. But the major issue on the 3rd floor is the exterior metal stairs. These are the only way in and out of the apartment, which is a real safety hazard, especially in winter. Strollers, buggies, shopping carts, garbage up and down exterior stairs. I'm not sure how you get an armoire up there. Are you supposed to have 2 exits for a building this tall? And it would seem the Ontario Building Code does not allow single stair exits 2 stories above grade, which these are. This alone should disallow this development. And I believe only 1 garden suite of a single story is actually allowable in our yards at the moment. We mustn't confuse them with the rules for laneway suites. With a plan for 18 units, 15% are supposed to be accessible. That would mean 2.7 units for the combined development. Despite convincing some neighbors to support the application based on this, there are no accessible apartments in these plans. The doorways, landscaping, and bathroom turnaround space in these plans simply do not work. You need a 5-foot circle to clear door swings for wheelchairs, and the only place possible for a redesign is the ground floor garden suites at the back of the property, only accessible via narrow strips at the sides of the buildings and a tight squeeze past the garbage shed at the front door. The unfortunate people who may rent the 2 front basement apartments will have a below-grade walkway entrance to their unit and a rack of 4 bikes in front of their window. 8 bike racks for 18 units and potentially 50 residents. I guess they'll be walking or parking their cars on the street. The applicant's agent likes to cite other nearby buildings to justify these variances. 2 churches turned into condos at the corner of Annette, 332 High Park, an old smelly auto body shop on a lane, 490 Quebec Avenue, again a former smelly auto body shop, part of the commercial Dundas wraparound on that street, and 301 Keel, which is a major street, nothing like High Park Avenue. We should not be comparing apples to oranges in order to cherry pick the desired outcome. The applicant's agent also likes to say the street needs gradual and gentle intensification. It's had that over the last 30 years. What is happening now is a developer offensive on our street. In the last 18 months, on the one block between 319 and 247, 3 projects, if all approved, will increase housing units by 48. This adds up to an assault on this grand boulevard lined with duplexes, semis, 3 and 6 plexes, condos, apartments in homes, single-family homes, and garden suites. Housing here is mixed. It already represents the missing middle and has significant densification. The official plan does not signify that this area needs more. Surrounding us on Dundas, Keel, and Bloor.
Ma'am, just a heads up, you're running out of time. Wonder if you could just wrap up, please?
We're not against more of the missing middle. We are against developments like this that are totally out of proportion, are not needed, contravene multiple city bylaws, provincial building codes, and are detrimental to the neighborhood and only serve the bottom line of the developer. We respectfully request a rejection of this development, and I thank you for your consideration.
Great, thank you, ma'am. Any questions? No? Okay, our next speaker.
Through you, Mr. Chair, our next speaker is Drew. Hi, Drew, you've been unmuted.
Good afternoon, Chair and members of the committee. My name is Drew Rankin. I reside at 2 Oakhampton Boulevard, and I'm here in strong support of the proposed development at 247, 249 High Park Avenue. This application will deliver 18 new purpose-built rental homes, including CMHC secured affordable units, through 2 3-story low-rise walk-up buildings with attached garden suites. This is exactly the type of gentle, missing middle density the city and the province continue to call for, particularly in transit-accessible neighborhoods like this one. This site is just steps from frequent TTC bus service and within walking distance of High Park Station, inside a transit-supportive area where planning policy clearly directs growth. The project makes efficient use of existing infrastructure, encourages active transportation, and adds housing without placing strain on city services. On policy alone, this proposal is well within what Toronto is asking for. But I'd also like to speak briefly about the human reality behind this application. My wife and I actively want to live in this neighborhood. We love Bloor West Village, the walkability, the schools, the sense of community. But like many young families, we simply could not find a home within our price range, either to buy or to rent. Even as 2 working professionals, the door was effectively closed to us here. A close friend of ours and his wife rented a small 2-bedroom unit on Clendenin for 11 years. They welcomed their first child there. When their second child arrived, they to stay in the neighborhood, especially because their son was already enrolled in the local daycare, but they could not find an affordable, suitable rental option. After months of searching, they were forced to move to Brampton, not by choice, but by necessity. Many older Torontonians understandably face their own challenges, but few have had to navigate a housing environment this strained, this expensive, and this supply constrained. For my generation and those younger than me, housing is not just difficult, it is often structurally out of reach. That is why recent housing announcements from all levels of government have been met with such strong optimism among my friends and my peers. But optimism alone doesn't house people. Until attractive community-based rental options actually get built, projects such as this one, this problem will only intensify. The proposal also demonstrates responsible planning and meaningful community response. The applicant reduced total variances from 38 to 12, internalized staircases to protect privacy, redesigned garden suites to be fully detached, stepped back the 3rd story, and is seeking no height or setback variances. The remaining depth variance is fully consistent with approvals already on High Park Avenue and required to improve livability and privacy, not to increase massing. This project replaces a structurally compromised building with safe, modern rental housing. It delivers affordability through federal programs. It supports families, seniors, and young professionals who want to stay rooted in the communities they love or to move to this wonderful community. This is not abstract policy. This is about real people being able to live, grow, and stay in Toronto. For these reasons, I respectfully request that the committee approve both the consent and minor variance applications. Thank you for your time and consideration.
Thank you, sir. Panel, any questions of the speaker? No? All right, our next speaker.
Through you, Through you, Mr. Chair, we have both Steph and Michael here to speak. You've been unmuted.
Good afternoon.
Through you, Mr. Chair, it looks like we lost that call, so we'll move on to the next speaker.
All right.
Next up, we have Sabrina Lee.
Good afternoon.
Hi, is it working now?
It is. We can have your
Okay,
name and
perfect.
address, please, ma'am.
Yeah, absolutely. My name is Sabrina. I live at 332 High Park Avenue, Unit 202, just a few doors up from the site. I'm here because I genuinely support this development as someone who's lived in the neighborhood and understands the area very well. For me, this project makes sense for High Park Avenue. This part of the city is already very walkable. It's a TTC bus route, close to both Dundas and DELAWARE and just minutes from Keele Station. It feels like the exact type of location where adding a bit more housing gently and thoughtfully is very appropriate. What I really like is that even though the building will technically be an apartment, it doesn't feel like one. From the street, it reads more like two large semis, which fits in with the existing homes around it. Inside, the units are actually livable sizes. There are 1, 2, and 3 bedroom options that are both spacious and very functional, not tiny or crammed. Every unit also has its own entrance and outdoor space, which is extremely rare in this neighborhood. The property itself is pretty large, but the amount of building being added is quite modest for the lot this size. The density they're asking for is very reasonable compared to what already exists around here, including 4-story buildings just across the street. And I was also glad to see that more than 40% of the site is actually being kept as usable green space, which with some units having private yards. That's something you almost never see in new rentals. The project will also introduce 2 affordable units, which is very important. It adds real diversity to the types of housing people can actually access in the area. A lot of the rentals here are either very old or high-rise towers, and this fills the gap that's missing. Well-designed, mid-sized homes that work for couples, families, and long-term renters. I also really want to acknowledge how much the developers have adjusted their plans. I know there were originally many variances and they significantly reduced them after listening to neighbors and city staff. They reworked their design, internalized staircases, and made changes that clearly show they're trying to be thoughtful and respectful of the community, which I very much support. I think that kind of willingness to collaborate really does matter in these types of things. Overall, I see this as a very positive addition to the neighborhood, something that brings more housing, fits the character of the street, and uses a large lot in a responsible way. For all these reasons, I do support the severance and variances, and thank you so much for your time.
Thank you, ma'am. Any questions, panel? None? All right, our next speaker.
Good afternoon. Antoine, you've been unmuted.
Hi, can you hear me okay?
Yes, we can. Name and address, please, sir.
Great. My name is Anthony Furlani, and I live at 34 Jackson Avenue.
All right.
Okay, so I'm a residential real estate agent that works in Toronto's West End and spend a lot of time professionally and personally in the area. So I'm here in support of the application because I believe it reflects the kind of gentle transition that both this neighborhood needs and the city is actively encouraging while supporting the goals of intensification. From my perspective, what stands out about this proposal is that it introduces new housing in ways that is firmly grounded in the context of the area, where low-rise rental multiplexes already exist. This is the gentle evolution we need to see rather than the disruption that is brought by mega-sized projects being proposed nearby and throughout the city currently. The proposal offers human-centric features, such as each home having its own front door, private outdoor space, features that align with what people want, rather than what is most profitable, and something that I'll see my clients are seeking when they're looking for comfortable, happy homes that they can live in. To me, the scale is measured and appropriate. The building is limited to 3 stories, and a meaningful portion of the lot is preserved as usable green space. It's a form of development that sits comfortably within the existing rhythm of the neighborhood, and I stress that many projects that are being proposed now are not. I would also emphasize the inclusion of affordable units as a unique benefit. Offering affordability broadens access and contributes meaningfully to the diversity of housing options available in the area. The unit mix supports a range of residents and household types. It's not full of single, 1-bedroom apartments, as we often see. And importantly, the density being proposed remains modest. This is a careful, incremental form of intensification that responds to the housing needs in the city while respecting the existing context. In comparison, I recently attended a community consultation just 2 days ago where developers proposing an FSI of 8.2 at 29 stories, abutting single-family homes where not even a single mid-rise condo exists at this time. I hear comments about accessibility, but I also note, and something I see very often, is that current stock of older homes typically are not accessible, and accessibility is can often be used as a burden to new construction when what is being replaced is not accessible in the first place. So in my view, this project represents the thoughtful, balanced transition the neighborhood and the city are seeking. It introduces the introduction of new, desirable rental stock in a way that enhances choice without overwhelming the area. Thank you.
Thank you, sir. Panel, any questions? None? All right. Next, how many do we have left? One is the last speaker, okay.
Through you, Mr. Chair, we have our final online speaker, Tom.
Good afternoon, sir.
Hi,
Good
Tom, you've
afternoon.
been unmuted.
Hello, everyone. Can you hear me okay?
Hi, yes, we can. Name and address, please.
Hi there. My name's Tom Mansfeld, 297 Hyde Park Avenue.
All right, sir, you have 5 minutes.
Wonderful. I wanted to join to voice my support for the project. I've been a resident of the neighborhood for 10 years, and much of the street is already rental stock, and this would be adding more rental stock that we desperately need in the city of Toronto. I think aesthetically it's pleasing and fits in with the neighborhood, and I would welcome it in my neighborhood. And I do know that the city needs much more of this kind of rental, and I support the project.
Okay, is that, okay, thank you, sir. Any questions this morning?
I'll be short and to the point.
Yeah, thank you, appreciate it.
Yeah.
All right, that's the end of our speakers, so we'll recall the agent. Hi.
Hello again.
Welcome back.
Thank you.
So we've heard a lot, both pro and con. If you could take some time to try to address particularly, I guess, the people who are in opposition.
Yes, of course. I'll try to be brief so I don't keep you much longer
And of those,
either.
maybe the concerns of the surrounding properties especially, we heard from the adjacent neighbor to the north who had the trees and.
Yep.
Yeah.
Yep, I have that one. I'll start. I'm going to have one overarching comment and then I'll go to that one first. So I would just like to note that there were some components that were raised in the deputations relating to height, setbacks, and the ability to construct the 2-story garden suite. Those are as of right. There is no variances required for those, so the developer could bring another proposal forward and all of that would be the same. So to the trees issue. So the concerns were raised regarding the removal of the private trees. So in response to the neighbor to the north, which was the first speaker, the applicant will not be removing any boundary trees, so that wasn't correct information. There are trees that will be pruned. The arborist report that was submitted does show that those trees have issues with them, and the applicant is preserving all of the necessary trees in the surrounding areas. They won't be affecting them. There are some trees that will be removed, but the applicant has submitted a tree preservation plan, which shows that they will be replanted following the development, and that's why forestry has no concerns. But to be clear, the neighbor to the north, the applicant is not removing any of her trees. Okay. The next I will go to the bike racks, which was the bikes, which was the third speaker. So the applicant has heard those concerns. The applicant would like to note that they are providing 4 spaces. There is an additional 2 that are required, but there isn't a program called the Payment in Lieu Bicycle Parking Program, which was established in 2022. They were planning to provide payment in lieu. They are willing to work with the neighbors and provide 2 additional spaces, which would be required if that will help resolve those concerns. So they've heard the concerns. They're continuing to want to work this project towards an approval.
You don't have a variance for bicycle?
There is no variance because they don't actually need one, because the payment in lieu program provides for those additional 2, and they're providing a minimum of 4. So they actually meet it. There's no concerns with that one. I just wanted to raise it because it was brought up. So the next one that I would like to move to is the soft landscaping. I'll just note that they have provided a substantial amount. I know there was a note of 25% or less, but that's actually incorrect. It's 43 and 41 for the respective lots. There were also notes about the rear, sorry? Oh, I thought I heard something. There were notes about the rear stairs. The rear stairs, I'm sure you are all aware, will be built to building code. So they won't be able to build unsafe stairs. Everything will be done in accordance to what they are required to do. They won't be able to get a permit or any occupancy if they don't do that. I would also like to note that there was a bunch of mentions that the minor variances are substantial in nature. If you look at Grace O'Brien, my friend's submissions, she actually includes a chart, and in the end of that chart, there is a substantial number of other variances that are similar or more to the one that is being proposed today, so 6, and they have been approved. The next is the privacy and overlook concerns. So with regards to those concerns, they're actually being addressed through the additional depth. I'm sure if you look out from your property, if you're further back, if you're further on your lot, so it's hard to explain, but if I could bring up my my letter at page 50. Thank you. No, sorry, I'm Katrina Burgess-Mail. I'm from Lucia Nixon. Yes, the cover letter. No, it was, no, so that's a planning justification letter. The cover letter is submitted by the legal counsel, which is Lucia Nixon. It was submitted on the 3rd within the time frame, so it was included. It was just uploaded on the 4th. I don't know if that helps you narrow down. No, that's still DPS. Sorry. Yes, this is it. If you could go to page 50, I believe it is. No worries. Great, thank you. So you can see from here, there is an orange line. It's a little hard to see. But if you're standing at where the building currently sits, I can clearly see the neighbor's porch. I can see their garage. I can see into their lot pretty well. But if we're pulling out that depth from further, it actually reduces your sight lines and increases the amount of privacy that your neighbors have because you don't have the same viewing space. So by increasing the depth, they're actually addressing a lot of the privacy and overlook concerns that the applicants, that the neighbors have raised. So I'd like to point that out, and I think the visual makes that pretty clear. They won't even be able to see their porch nearby because the building will be where the line is. And then finally, the as of right building. Sorry, can we just pause it for one more second so you can bring up Grace O'Brien's letter now? It's just hard to jump between them. But she brought up the photos of what her architect had drawn as to what would be permitted as of right. So it sort of nitpicks what they wanted to do because it's not actually factually correct. Because they're not requiring any setbacks, front yard setbacks, rear yard setbacks, or anything of that sort, they can actually build within the footprint that is provided in that letter. It's just that they've chosen ways of how to present it in a way that looks unfavorable to my client, but misrepresents what's actually permitted as of right on this. It's the page that was just 2 before. Or 3 before, maybe one more up. Yeah, it was that one. So they can build within their larger gray box if they wanted to, because all of those permissions are as of right, except for the rear yard, the portion of the depth that they are requesting. So I would just like to take a moment to conclude. I know I'm almost out of my time.
I'll give you a little bit more time.
Thank you. I'm just going to find my conclusion page because I've now moved everything all over. But as we've noted, the applicant has made every reasonable effort to work constructively with the neighboring property owners, even such showing that they've made some changes, though they're willing to make some further changes to their application right now. Several design refinements were incorporated in response to the feedback that was received, resulting in a proposal that's more compatible with the surrounding context and exceeds applicable requirements in a number of respects. We respectfully ask that the committee take this into account in its deliberations. This proposal represents a positive addition to the community. It will deliver much-needed, attainable CMHC-supported housing and contribute to the housing supply at a time when such options are urgently required. As in the recent words of the Committee of Adjustment, although High Park is not a major street, it might as well have been, and if it's not here, then where? We respectfully ask that the committee approve the severance and consent applications.
Great, thank you very much. Okay, Dino. Yes, Dino, yep.
To the deputant, your client retained a planning consultant, and that planning consultant from Design Plan Services submitted a planning justification report. Is that correct?
That is correct.
And Mr. Eagleman is not here today?
No, he is. He's just virtual.
Oh, okay.
Yes, yes. He's here if you have any questions. He's here and he is able to answer them so long as he's muted.
Okay, so we're dealing with, obviously, a number of applications. We're dealing with the consent application and, of course, the associated variances on the two lots.
Yeah, 3 in total.
I would question the argument that Mr. Eagleman provided in his justification report dealing with sections 5312 and 5124 with respect to policy 4.1.5 of the official plan. OPA 320 introduced the concept of prevailing, and prevailing in that discussion in the OP talks about the immediate context as opposed to the broader context. And I know that Mr. Eagleman has provided an analysis of lot frontage and lot area. I would suggest that the majority of lots on the immediate context, which is High Park Avenue, are 12 meters or greater, the lot frontage, as opposed to 91%. It's more like 75%, the larger frontages.
Okay.
Do you agree with that?
So you're saying the larger frontages of the neighboring properties to the south?
Prevailing, because the immediate context is the street, the street that the lot is on.
The lot frontage that they're providing, though, meets the requirements of the bylaw.
Right, no, I'm just questioning the numbers. And as well, in terms of the lot the lot area, I agree that 55% are greater. Again, if you're looking at the immediate context, they are greater than the proposed. So I'm okay with that number, but the lot frontage, I think.
In this case, if I may, this property was originally 2 individual properties. They were separated. It was just one owner had previously purchased it, and I'm sure under the Planning Act, you're aware, they then merge on title.
Yep.
So they're just looking to restore that original. So it's actually restoring the historic feature of what this property originally was. So it's not like they're trying to change the character of the surrounding area. They're just trying to bring it back to what it was before because it was purchased by someone who didn't allowed it to merge on title.
Oh, great, but you agree that what we have before us is a consent to sever?
Yes, it's a consent to sever.
Next question is, Mr. Eagleman says in his report, the increase in building depth is required to create functional units. Is that?
The only reason that is required is because the neighboring property owners have requested that the front yard stairs be enclosed, and in order to enclose them and then allow for still functional units, but I would have to confer with my client to ask if they were to unenclose those front yard stairs, which were done at the request of the neighbor. I don't think they would require such a depth increase, and then it would still allow for livable units. But the rationale was the fact that because they're enclosing those stairs, then it reduces it, so they asked for the increased depth, so that way they could still allow for those livable units, which I'm sure we all have probably known someone that lives in a shoebox, because I sure do, and no one likes it.
So that's the explanation for
Yes.
the term functional units?
Yes.
Okay. And then finally, in terms of you've heard concerns about the exterior stairs. Can you explain why you're providing those exterior stairs?
I would have to have my client provide that explanation, if he may just
Sure,
join me.
come on up.
Sure. Those are my questions anyway, so.
To answer your question, sir, the exterior stairs are required as the main and dedicated access for the third floor units. So all of the units we're providing have a dedicated entrance, and that is to ensure better quality of unit, so you don't have to interact with other tenants in common spaces.
So the exterior nature of the stairs, if you were to put them internally, that would impact, obviously, your proposal.
We wouldn't mind necessarily, however, that would increase the FSI number we're going for. So
yep.
That was the reason for keeping them as external stairs.
Okay, thank you.
Yeah, and I wanted to probe that a little bit. I mean, the external metal stairs, frankly, I'm not a huge fan of them. I frankly think they're ugly. But I do get your point about if you enclose them, then the massing
It
is
changes.
even, frankly, worse.
And these are widely used across the city.
Yeah, I know. And we're seeing them routinely on multiplexes. But I did notice that on your floor plan, so your second story has internal, both rear and front?
Yeah, that is shown currently, although we will likely just dedicate that to the third floor. I think that was just an iteration that was on the plans, but that stair will be dedicated to the third floor.
So the exterior stair will only be for the third floor?
Correct.
Because right now it's connecting to
It
all
is,
the other
but
floors.
so the second floor units have a dedicated
Yeah,
stairwell,
that's
as you
what I
can
was
see.
saying, both front and rear, right?
Correct.
Yeah.
Yeah, so
I-
those
I-
will be the main entrances for those units, and
Okay.
that exterior stair will only serve the third
So
floor.
code would require the same configuration with the
Correct.
exception of access to?
It's
no way
enclosed
to
only for the third.
Crunch
yes.
it a little bit, or I guess not?
Yeah, well, there's certain distances that you have
Yeah,
to
I mean,
abide
I
by.
get the fire code and building
Mhm.
code, but
They'll be built to code, and they will be built out of metal, which is required in this scenario.
Yeah.
Yeah.
no, I just look for opportunities to minimize the visual
Yeah, I mean,
impact of
we,
those.
I mean, we're happy to provide some sort of privacy screening.
Which
To,
in some respects makes it even worse, because again, it contributes to the massing, right?
right, exactly.
Okay, sorry, I saw a couple of hands over here. Phil first?
So while we're on the stairs, though, to be clear, another reason for having the exterior stairs going to the third floor is by having a separate entrance for each one of these units, you're avoiding needing the dual stairs that you would need otherwise,
Well,
if it was a common.
that is correct. It would eliminate the need for a secondary entrance. However,
Yeah.
the reason we're providing dedicated entrances is for a better tenant experience.
Well, it does both, but also.
Well, that's why we're doing it.
Okay, that's
Yeah.
why you're doing it. Yeah, I also think it's important, just because it's something that one of the members of the public raised, that, don't you need a dual staircase because it's
Yeah.
3 stories? The building code doesn't actually require that with the
That is
dedicated
correct.
entrance like this. This is all to code.
And we have used this on other properties as well.
Yeah.
Yeah.
Maybe to council, just very quickly, again, because it was raised by a member of the public, I'd like you to address the concern we heard about your affidavit.
So I did not commission that affidavit, but to be clear, Commissioner is not someone that is signing it. They're just simply stating that it is, that the person signing it is making the declaration truthfully. So I can sign my husband's. It's not a conflict of interest, and me and my husband actually do that quite frequently because he's also legal counsel for another law firm. But we would often do that because there's actually no conflict there. It's simply that I declare that the affidavit is true, or he does, depending on who's commissioning it. So the fact that Ryan signed it and someone from his corporation commissioned it has no bearing on the actual validity of it. It would just be whether Ryan signed it and that he declared it to be true and went through the proper steps, which I'm sure they did. But we would have to ask them, which is something that can be done.
Absolutely. I just wanted that for that member of the public. I'm a lawyer as well. I commission my clients' affidavits
You
all the
understand.
time. Not being able to commission your own client's affidavit as though that were a conflict would be very problematic to the practice of law, but I just wanted it out there that that was not a problem.
I would like to add, all the information in there is 100% true.
Well, whoever swore it believes it because they swore it.
Sorry, it's his affidavit.
Oh, it's his
So he did
affidavit.
swear,
Yeah.
yes.
Okay. Those were my
Okay,
questions.
thanks, Katie, you had a question.
Thanks. One of my questions about just clarifying the use of the exterior stairs got addressed, so thank you. My other question is just around definitions of affordability for all these units. I know that a certain percentage of the units are tied to CMHC secured funds. I heard in one of the letters that was described as being secured for 5 years. I believe you spoke to it being secured for 10 years when you spoke.
Sorry, that was a typo. I think my clerk had accidentally made a change there, but it actually is 10 years.
10
so
years?
I apologize for that oversight when we submitted.
No, no problem. Thank you. Am I correct in understanding then that those terms are applied so to 10% of the units? What are your definitions of affordability for the other units involved in this project?
I can speak to that. So CMHC has certain rules in what you can charge. They're different in every market. So in Toronto, it is $1,350 per month. So as long as you charge that, that is deemed affordable. So you have to have a minimum of 10% of your units as affordable. In this case, that's 2, which gives you a little more than 10% to meet those requirements.
And for how many years, sorry?
So it's 10 years, but we have designed them in a way where for the entirety that we own the property, that rent will stay the same, even if we exceed the 10-year period.
And so that definition of affordability applies to those 2 units.
Correct.
The rest of the units will be market.
There'll be a market rent.
Okay, thanks.
Anyone else? So, council mentioned, I'll direct this to you as the owner, the bicycle parking thing. So are you planning to top up your bicycle parking?
We're happy to provide more. So the reason for it being in the walkout is you have to have a certain amount of long-term spaces. It's 0.9 spaces per unit, which gives you a little over 6 spaces total that need to be covered to be deemed long-term. So we provided 4 in the walkout. We're going to do payment in lieu of the remaining 2. We're happy to provide more, whether that's in the walkout or on the exterior of the property. That's not an issue for us.
Okay, good. So we could do a condition to that effect. Go ahead, Ryan.
I just had a question about the current building. Has renovation of the current building ever been considered?
Well, it's in such rough shape, and with the resevering of the lot lines, it wouldn't make sense in this application.
Thank you.
Okay, any more questions, folks? One last one. You've set back the 3rd story in the rear. Great. Again, reduced a little bit of the massing. But is that like a rooftop patio that you've got back there?
Well, it's a walkway to the door, so you're allowed, as of right, I believe it's 4 square meters for a rooftop patio, so we'll comply to that, and it's designed to comply with that.
So it's just a walkway, so it's not,
Correct.
It doesn't span the width?
No.
Okay. I was just concerned about overlook if people are using that for recreation, for example.
Again, happy to provide privacy screening.
Maybe that one is
Sure.
not a bad idea, because that faces the rear yard, and that's the ones where
we're fine with that.
neighbors are concerned about overlook.
Understandably, yeah.
Okay.
One last question,
Yeah,
if I
sure.
may. It was implied through the materials and the presentation, but just to clarify, the current building is completely vacant?
It's completely vacant.
Okay.
It was vacant when we purchased it. I even checked with the city while we were in due diligence on the property, and they confirmed that it was registered. Both properties were registered as single-family homes.
Oh, Ryan, did you have a question?
No,
Okay.
no stretching.
Okay. All right, any further questions? Okay, let's take it into committee. Thank you very much.
Well,
Who wants to start? Ryan?
Yeah, I can. I mean, I'll note that this project has significant opposition, but significant amount of supporters. Typically, only people who are opposed to projects come out, so happy to see both sides. I think we have an unused building that's in disrepair, and that's a shame. There's commitments to affordability outcomes here. That's very positive for the city, for the neighborhood. There's increased density in proximity to rapid transit. It's policy across the province to build transit-oriented development. And you know, planners often talk about the missing middle, and I find this proposal supportable because this builds the missing middle that we're looking for in Toronto. Thank you.
Okay, thank you. Go.
Yeah, I was also going to commend the community on coming out, both those in support and those opposed, and particularly those in proximity who are in support. It takes more effort to come out for something that you're in support of than for something that you're not in support of. It's human nature. But for all those who are affected in the neighboring properties, it's good to hear everyone's thoughts, and it leads to better decisions by the tribunal. But I view this as supportable. I think there are a few things to note. So we had another application on Hyde Park just a hearing or two ago, and I noted in that one that there's sort of no major streets between Keele Street and Runnymede, and I'll note it again, and that Hyde Park is sort of the street that most fits that bill, and we're seeing, so if this was a major street, a much larger up to 60 unit apartment would be as of right here. Now, even ignoring that though, and before major streets changes came in and any of that, it's notable that this is a lot that is already zoned for apartment buildings. You know, there's no variance here to have an apartment building. This is an apartment building lot. So I don't see this as overdevelopment. I do appreciate that these are reasonably sizable units that each have their own entrance, that have some outdoor space. I think there are some great points about these being very livable units, and a good number of them in a location that frankly is expected to densify. And you know, it is right across the street from a much larger apartment complex that's going up right now. So I see it as supportable, very much in keeping with the official plan and the direction that the city is going in these areas. And I think it's also notable that they've managed to do it with only 6 variances for each lot, of which there's only one variance that has sort of a number that jumps out at you, and it's the depth variance. And I think they've done a good job of explaining why it needs that and how it's contextual to the area.
Okay, yeah, I'll just jump in. I agree with you both. I would just add a couple of things. First off, one of the variances is for a duplex garden suite. And you know, there is on the record a bylaw that says you can only have 1 unit in a garden suite. I think that might be something that is only applicable in certain unique cases. I don't see this as being one. In fact, I think in this case, the garden suite complies with height. They've got an angular plane in the rear, so it reduces the impact. There is no overlook on either side. There's no windows on either side. And it can accommodate collectively 4 units within the 2. And I think that, frankly, I think that really does in fact support council's interest in promoting garden suites and additional density on lots. I think the tree question has been answered. I fully appreciate that that was a concern by many in terms of you know, removing or injuring mature trees. So I think the agent did a good job of explaining exactly what the circumstances are for trees, and the involvement of urban forestry should give people some comfort that anything that's done will be done in according to the rules and regulations governing trees in Toronto. I would also note, like the agent said, you know, it's probably me who says these things, if not here, where this is in a broader context. This street is, I think Phil makes a really good point, is that it's deep lots, large setbacks from the street, and the width of High Park Avenue is actually considerably more than most of the streets in that neighborhood. So it does present, and to a certain extent serve a purpose of a secondary avenue. So it does have transit. It is walkable to High Park, you know, the city's largest park, and provides recreational opportunities. It is near schools. It's high schools, daycares, public schools. It is also walkable to the junction. You have transit on Annette. I mean, it is, frankly, one of the reasons why this area is garnering so much attention is because it is located so well in juxtaposition to so much. So it's not surprising that you're seeing a great deal of interest in terms of additional density. It is an ideal location for rental accommodation. It's an ideal location for people, and particularly families who want to locate and live there, because the amenities are very rich. And lastly, I agree with my colleagues, there's only 6 variances, and if you look at them both individually and collectively, they are quite minor. The only thing is the depth, but I think given the depth of the lot, or the length and the depth of the lot, I think it's a large lot, and I think it can accommodate this density. Those are my comments. Phil, or Dino?
Thank you, Mr. Chair. I would also echo the sentiments that I appreciate the people that, the residents that came out, both in support and opposition regarding these applications. I have no issue with supporting the consent and the main building. I was a bit conflicted about the garden suites. These are 2 very interesting properties, lots, with that jog towards the rear of the property. I think that's what creates the massing issues regarding the garden suites. But I mean, I acknowledge the planning experts' statement that there are no variances required for floor area, setbacks, height, or lot coverage for the garden suites. That's actually interesting to me that that's the case. I know that City Council recently removed any maximum FSI requirements for garden suites. I will say that I think that if these were, garden suites with 1 suite per garden suite, I think the configuration might be smaller and less impactful. But nevertheless, I will reluctantly support if my colleagues are putting forward an approval in that regard.
Okay.
Thank you.
That's great. Katie, you're good? Okay, so who wants to take a crack at a motion? Phil?
Sure. So I will move to grant the consent and approve the variances for both applications. For the variance applications, subject to the condition that 2 additional was it 2 additional bicycle parking spaces?
Yeah, I think that's what you said, yes.
Yeah, 2 additional bicycle parking spaces be provided per lot.
And the screening for the
Oh, yes, and
north and south sides?
For perhaps staff can work out which of the application B and C it is, but for the northern lot, that there be privacy screening on the north side of the 3rd-story platform, and for the southern lot, that there be screening on the south side of the 3rd-story platform.
I believe there's also an urban forestry condition, or 2?
Yes, absolutely, and those
Yeah.
are important. So urban forestry condition 2 on both variance applications, and of course, the standard engineering conditions for the severance.
Was there a engineering report? There wasn't?
I don't think there was a particular one.
Through you, Mr. Chair, it'd just be the standard conditions of consent.
Okay, great. All right then, thank you, Phil. So motion by Mr. Ghosh to that effect and those conditions, seconded by Mr. Bissonnette. All in favor? The application is approved. Thank you all for coming down.
Thank you.
Thank you.
For all your time.
Okay. Do we need a 5-minute break?
Through you, Mr. Chair, let's take a 5-minute break. Please turn off your videos, microphones.
Get up and be close to it.
Yeah.
We called them out. And you know what, we said it's simply, it's not yet HARVIE. Well, what you could have done, it's a lot more.
Okay, members, please turn on your videos, microphones. We'll unmute the room.
Okay. We resume with item number 19 on the agenda. 521 to 523 Brunswick Avenue. This is an application to construct a new 3-story detached dwelling with a front covered porch with stairs, rear basement walkout with patio, rear ground floor deck with stairs, and a rear 3rd-story balcony. Also, the existing front yard parking pad will be maintained and unaltered. The existing 2.5-story semi-detached dwelling will be demolished. Committee has this is 521. 523 is slightly different, so I'll read it. To convert the existing 2.5-story semi-detached dwelling into a detached dwelling. This dwelling will be altered with new insulation and cladding to detach it from the attached dwelling to the south, known as 521 Brunswick. The existing front yard parking pad will be maintained and unaltered. Committee has before a copy of the minutes from the November 19, 2025 public hearing and the materials. We have a copy of the plan of survey, site plan, floor plans, and elevations, presentation materials from the agent. We have commenting reports from community planning and materials in opposition from 519 Brunswick.
Through you, Mr. Chair, it should be noted that these applications are associated with a consent application for a lot addition. That lot addition application has been refused. Decision will be sent out next week.
So how does that affect what is before us?
The applicant will have to speak to that.
Thank you for that. All right, do we have the applicant? Is it here or online?
Through you, Mr. Chair, we have the agent here in person.
Hi,
Please come forward to the podium.
have a seat. And name and address once the mic goes your way.
Oh, sorry. Through you, Mr. Chair, also, we also have registered speakers online.
Okay. So name and address, please.
Thank you, Mr. Chair. It's Raj Kehar. I'm counsel for the applicant in this instance, and it's 66 Wellington Street West, Suite 4100. And next to me is our client's architect, Mr. Alex Horbert. And Alex, if you just give your address.
It's, 174 Spadina.
Okay.
Suite 200.
So before we start, are you aware of the decision?
No.
No, we were advised, and we actually made the request as late as a few days ago, that what was happening with respect to the consent application is that it was going to be determined by the Secretary Treasurer, but that it was deferred pending a decision on the minor variance application. So we're really surprised by that, and I'm almost wondering whether there might be an error that occurred, given the inquiry I made not until very recently.
Through you, Mr. Chair, it's actually done by the Deputy Secretary Treasurer, and decisions are made separately.
Yeah, so.
Right, so it's not relying on what happens today through the minor variance, that's done separately.
Right. So you've got a decision that is stand, I don't know if it's appealable. Is it appealable?
Through you, Mr. Chair, yes, it is.
So you have some options before you, right? So without that positive decision, I guess it's up to you. Do you want to proceed, or do you want to defer until this gets resolved? How would you like to proceed?
So I think in the circumstances, we'll proceed, so that way we can get a decision on the minor variance application. And then we'll make a separate inquiry as to what has happened in terms of the refusal of the consent, which I'm surprised occurred from an administrative standpoint.
Right.
But of course, if that's the decision, you'll have to exercise what rights we have associated with it.
Okay. So just so we understand, so the variances, we will consider them, and as we do these matters, but if that decision stands, then the variances are kind of moot.
Yeah, no, and that's understood, and I appreciate that we can still file another consent application to call it reconsider what is effectively a very small transfer of the lot line. So I'm actually really surprised that that decision was made before the committee had an opportunity to consider the variances.
Okay, so you want to proceed. We do have someone who wants to speak to these items, so.
Sorry, can I just ask a question?
Are you speaking today? Okay, you'll get an opportunity when it's your turn. Okay? All right.
Okay, I apologize.
No worries. Okay, sir, you have 5 minutes.
Okay, thank you so much. And I will just start by clarifying that that consent application, all it was doing was taking the south lot line of 523 and moving part of it 0.25 meters onto the 521 parcel, making 521 slightly smaller, 523 slightly larger. Why are we doing this? We have a semi-detached unit today. My client owns 521 and is agent for 523, and we're trying to turn them into 2 detached units. Now, I'll start with the variances for 523. There's 2 variances for it. That's not the image you see on the screen. The image you see on the screen is in relation to 521. But for 523, there's 2 variances. The first variance is an FSI variance. We're asking for 1.4, whereas 1 is permitted. The existing FSI of the existing semi-detached that's on that property is 1.34. We're asking for the FSI to go up by 0.06. Why is there a slight increase in FSI? It's simply when we detach the building, we've got to add some cladding on that south side wall. We've got to put some insulation in there, and that's what adds the extra GFA that triggers the additional FSI. The second variance we're asking for in relation to 523 is in relation to the south side yard setback. It's today 0 meters because it's a semi-detached. Post any approval of the variances, we're asking for it to again stay at 0 meters so that when the lot line moves, effectively it moves right where that wall is going to be. That's it in terms of 523. Otherwise, building staying exactly the same. We're not changing anything. It's going to look like what it was before. 521 is the one where we've got a reconstruction. That's what you see on the screen. And there are a number of variances here, but I think when you see the components of them, they're all really technical in nature. And I put to you that they're all minor. I'm going to break them down into the themes. There's FSI, there's height, building depth, front and rear yard setbacks, and some technical variances. So on FSI, the zoning standard here is 1. We're asking for 1.21, and the existing dwelling on the site is 0.96, the semi. So it's a fairly modest increase of 0.25, and when you see how that manifests itself on the lot, I think you'll agree with me that it is fairly minor. Height, and I'll get to that in a moment. In terms of height, you see on the screen, there's that little red area that's shown that looks kind of like a chimney. That's the entirety of what is actually the height variance. This is an area where 13 meters is permitted as of right. We're going to 13.5, and that's the little bump out that you see in the red. What you also see is the main wall height is the same. We're meeting 10.5 on the side main wall heights. It's only the front and back that get increased, again to 13.5 because of that jut out. That jut out is not a floor, it's a skylight. There's also a height variance for the porch, and you see that on the screen, and it's fairly modest and screened by a structure in the front. The next thing is building depth. And for building depth, we're asking for 25.3, and that numerically sounds high in compared to the 17, but it's not. And the reason it's not is if you look at slide 9, if you could just go there for a moment. PDF page 9, sorry. Yes, thank you. Okay, so 17 meters, our entire 3-story structure, the area you see it gray and you see a line there, that 3-story structure is entirely within the 17 meters. That's as of right. When we go beyond that to 21 meters, that portion of the structure is one story. It's about 1 1/4 stories tall. So anything beyond the 17 is 1 1/4 stories. And then everything beyond the 21 meter mark is 1.4 meters sloping down. And that's really the basement wall from the stair platform down to the bottom. That's it. So while the number numerically sounds high, it's actually very small. Front yard and rear yard setbacks, same kind of story. The rear yard setback is 5.75 when 7.5 is required, but it's actually not that big because that 5.75 is going to that basement wall again. The actual 3-story structure, the main portion of the building, is over 14 meters away from the rear lot line. The front lot line, same sort of kind of story. 6.51 meters is the required. We're proposing 6.08. We're aligning with the houses to the north and to the south of us. And I can tell you in terms of that front yard variance, it's 0.43, which actually is, as of right now, under the Planning Act because of the new 10% rule. We've got a required front yard soft landscaping variance going from down from 75 to 62. But that reduction is actually an improvement overall, because if you look at what's there today, we only hit 36% today. So we're adding more soft landscaping in the front. There's a minor stair encroachment variance at the back, but that's aligned with the building itself. So I'm gonna submit to you that that isn't an issue. And we're, again, putting a parking spot in the front where one was already there, and there's a variance for that. And I know I'm out of time, so I'm simply gonna end by saying this. This has been reviewed by city planning staff, by a number of departments. None of them expressed any concerns. And in fact, city's planning staff effectively wrote a positive staff report simply indicating that if the committee was going to approve these variances, it should do so making sure that the variances are conditional upon certain plans as it related to the 521 property, which perfectly makes sense given the numerical numbers and how they actually manifest themselves on the plan. So that's what we're hoping, that you will approve the variances because they meet the 4 tests and are otherwise good planning to approve.
All right, sir, thank you very much. I think we'll hold questions until we hear from the opposition. That's okay?
Thank you.
Great, thank you very much. Ma'am, are you here to speak? Yep. Come on up.
First of all, I apologize for speaking out of
No
turn.
worries,
I didn't
no worries.
understand.
It's quite fine. No problem at all.
Okay.
If you can give us your name and address, please.
My name is Marjorie Kramer. My address is 519 Brunswick Avenue. We are the property to the south of 521. We abut it directly. So I'd like to speak to anything else. I'd like to speak to the variances on a few topics. First of all, thank you for giving me the opportunity to speak to this. So as a summary, there are 10 variances of the requested. And if you look at the sum of the parts, they're not minor, they're large. They impact us incredibly, and we'd like to speak to that. First of all, which I don't know if I should mention, but the severing of the lot. We could say that's going to happen. If it doesn't happen, then we'll have to revisit it. But the fact that they're severing the lot decreases the size of their property because they're pulling the north wall back off of the lots by 0.5. And to get that back, they're moving the south wall closer to ours, which would result in about this much distance between the two houses, which is about 1 meter. So that's something to consider. Increasing the FSI to 1.21. So basically, the way that they're getting the additional square footage that they require is by changing which is not mentioned, is changing 2.5 stories to 3 stories. Every other house in our neighborhood, so if you scroll to the first slide, or anyway, don't worry about it. Every other house in our neighborhood on that side is 2.5 stories. So they are now making it 3 stories, and it will impact our house and our third story as well. The main wall height is, although it's 10.5 meters, it goes up to 13.5 meters, which is huge, and that will impact, those two things themselves will impact the shadowing and the enjoyment of our third floor property, because it will go all the way back over to the extra half. It's coming closer and it's going higher. As well, in consideration with the depth increase. The depth increase is going, it overlaps our property and will be higher and be closer, as I emphasize again, so that when our third floor, when we look out, we will have less visibility of our surroundings, and the light will change and the shadowing will increase. In addition, something that wasn't mentioned, this is a change. They're making it a single-family unit. It, at one point, had 2 rental units. So they're increasing the FSI without increasing the density or increasing the number of units within the building. Just a question. Another point is, all of this comes together. We were the ones who consulted with our neighbors to get sign-on, and the properties to the north and to the south of this were very concerned, along with us, for having encroachment, higher wall, which would encroach on their enjoyment, also setting a precedent in the neighborhood to make more buildings 3 stories versus 2.5 stories. And to make the point too, we were introducing them to the issue. The way that it was communicated was not from the applicant, it was from the people in opposition. And when we spoke to the applicant, because they did confer with us, they were very concerned about making sure the neighbors were okay with it. And there was no reach out on their part, so that's something to consider. We would like to say the cumulative imposition of these requests creates conditions which do not fit within the intent of the zoning bylaw and impacts us immensely, the 519 Brunswick. And we would like you to consider this in your denying of the variances being requested. Thank you, and I appreciate your time.
Thanks, ma'am. Panel, any questions from the speaker? Yes, Dino.
Yes.
Thank you. To the deputant, there is no variance for number of stories. You're aware of that?
Right, there is no variance to the number. I'm just describing the impact.
Right.
Right.
And in terms of the street itself, there are quite a number of properties that have dormers or sort of an attic in the 3rd story or something to that nature in terms of architectural features.
In the back?
No, in the front.
Oh, I'm talking about in the back.
Okay, sorry.
So that's what I'm talking
okay.
about, excuse me. So
Okay.
in the back of the house, there's literally a pullback.
Okay, thank you.
Yeah, excuse me.
Okay, thank you. Phil?
Did you have a question for the applicant? You know, when you were in the audience, you said you had a question. Was that just a procedure question, or?
I was just shocked. I appreciate you reaching out, and I was surprised. I was not aware that the severance or the increase, I didn't know it was denied.
See. It's just if you had a question for the applicant, we could pose it to them.
Oh, I wanted to understand what the impact would be on the lot size and how far they would pull back if whatever changed. So they're not increasing the lot size? I just don't have.
So the lot size is actually decreasing because what they're doing, and they'll correct me if I'm wrong, but because they're severing from a semi, they're giving the bit of the wall, that's the party wall
Right.
that they need, to the other property.
Right, and then that wasn't denied, or was it denied?
It was.
Okay.
Yeah.
So their lot would be increasing? I'm sorry.
Right now, they are just asking for these variances, and
Yeah.
that's a separate application.
So I would like to point out then, whatever the lot size is, the FSI will change, right? Because you base that on the
It's
lot
based on the
size, and something to
configuration
be
of the building
considered.
on the lot, yeah.
Yeah.
Yep.
Just to point out.
All right, thank you very much.
Thank you
ma'am.
very much.
That's-
I appreciate your time.
You're welcome. And that's it for speakers, so we'll have the agent back.
Through you, Mr.
Oh,
Chair,
sorry, there's another speaker?
yes, we have an
I apologize.
online speaker.
I'm sorry, I didn't realize we had another speaker. Sorry, guys. All right,
Hi, my name is Alan Gothenberg, and I am from 519 Brunswick. I just want to carry on from what Marjorie was talking about and just
Sorry,
highlight.
are you related to
Yes, I am.
Marjorie?
Yes, I am.
I thought our rules were one, I'm sorry, we can't really accommodate you. Our rules stipulate that if you live in the same household, then we only go with one speaker.
Where were those rules? Where do you see those rules? Sorry,
They're-
I didn't know that.
Yes, they're in the procedural rules, so, I'll grant you just a very, very brief opportunity to, if there's anything that Marjorie didn't raise, if you wanted to flag it.
Yeah, I wanted to just 2 points, if you don't mind. There's one we sent in some drawings that show how the third floor impacts our third floor. And I'd like to show that. It's just some sketches that I did. Not that one. There was.
I think it's in supplemental.
Yeah, it's in supplemental. It was for the previous. It was in the deferred floor. And it looks like this. I'm not going to show it, but I'm not. So by in opposition. That's the letter. It would be the bigger size file.
Is this the one, materials in opposition?
Yeah, that's, no, 521 materials, that's for. You don't see it, because it was there online.
That's the letter, right? This is the letter. Yeah, it just says attached.
All right, sir, for whatever reason, we can't source it, so I wonder if you could just very quickly verbalize what you want to share with the
It
committee.
basically just shows really how the third floor addition, based on the extra height that they have, that they're adding on, really impacts our view and the light coming into our house, and the fact that it's as a result of the height, but also the fact that their south wall is basically getting squared out. So the impact to us is significant. The other, just the one last thing is just on the FSI. I tried to get hold of the zoning just to understand how the FSI was calculated, especially when I was looking at the markers that they had for their property line. And it looked like there was something that it didn't make sense to me, and they didn't give me information because they said they cannot provide me information. So I'd really like to understand, is it really 1.21 or, what is it?
Okay. All right, sir, we'll pose that to the agent. Thank you very much. And now, gentlemen, if I could have you back up, please.
Thank you. So I have a few brief submissions in reply. The first is that if you think about the back of 521 and the back of 519, where their back walls are, we're aligning them. We're not going further than 519. We're aligning with 519. If you think about the wall that you're hearing is a concern from 519 that would be on my client's property at 521, that is at the 17-meter depth line. There's no variance for that. The height of that wall that they would see, the main wall height, no variance for that. The variance on height is that little thin strip that looks like a chimney for the skylight. That's what the trigger is. Now, I heard shadow as a concern, and what I would simply say is our property's north of 519, and so the shadow impact during the peak hours doesn't happen in that direction. So I think they can take some solace that there isn't gonna be a shadow issue here. The 2.5 versus 3 stories, I think one of the members of the committee pointed out quite aptly that there is no variance to go up to 3 stories. The variance is a numerical question in this area, and in this area, really, it was that little red strip that I pointed out. That's all we need from a height standpoint. In terms of how close our wall is to their property, we are building at the as-of-right side yard setback of 0.45, and we have no windows on that wall, so there's no concern about privacy or overlook, and we can't have windows because, of course, if you're at 0.45, you're not allowed to have windows, and that's what we're doing in that area. I would say that in terms of the reshaping of the lot, it is 0.25 meters that it's being moved over. And it's a sliver down the middle, right where that wall is. And so that is the case that it makes the 523 lot slightly bigger and the 519 lot slightly smaller. But the FSI calculations that are contained in the architectural plans and that we're seeking variances for are assuming the conveyance is authorized and happens. So we based it on post-conveyance land, not pre-conveyance land, to make sure the FSI calculations were accurate. What I would say is I know we're in a bit of a unique predicament given that, and I don't understand why, and we're going to follow up, that the Secretary Treasurer, Deputy Secretary Treasurer made the decision they did, despite the fact that there was a positive staff report on the consent. So that's what really is sort of perplexing me. But what I think the committee could do if they so chose to approve these minor variances is it could put a condition on the variances requiring the consent to be approved. So that way I have my minor variance approval, and then I can follow up with the Secretary Treasurer or the Deputy Secretary Treasurer, find out what happened with the consent. Maybe there's a way to fix it. Maybe I apply for a new one. Or if not, and there really is an issue and it's unfixable, then I can obviously exercise rights to the TLAB if necessary. But I think putting that condition protects your decision if you want to approve this without undermining what has happened on the consent application. I'm subject to questions you have. Those are my submissions.
Dino?
Thank you, Mr. Chair. Mr. Kahar, I'm looking at your, I just want clarification, the A705A east elevation proposed drawing. I just want to confirm that, so the first variance, which is a 0.5 meter increase in building height, that's related to the narrow part of the proposed structure, the height?
Yeah.
And the building height, exterior main wall, building height, the 3 meters, 10 feet, is where the narrow reaches the top part.
Exactly. Like there's no change in the main wall height. There's no, and the 0.5 on overall height, and it's that chimney, what I call the chimney.
Chimney,
Yeah.
Yeah, okay, great, thank you.
I think this is a very interesting design, and the architect's here, so I'll just, say it's an interesting design. I guess what I'm troubled with on this one is you're asking for 0.5 meter over the height variance, which is already a very generous height bylaw, I will say. I mean, 13 meters is pretty unusual for a residential street in Toronto. We did double check into it, and that actually is in fact the case. But that third story, for that, I'm going to use the word chimney, I apologize, that's a very crude way of describing it, but that makes that ceiling height for their 12, 13 feet high. It just strikes me that, and I appreciate it's part of the architectural design, I'm having trouble with a 13.5 meter height variance when 13 is permitted, and it doesn't look like it's, the utility of that design doesn't hit me. Like, it just seems to me that I don't see the reason for the need for an additional 5 meter or 0.5 meter for that. So I'm concerned about the height, and I get the fact that the vertical portion of that structure contributes to the sidewall height too, right? That's just an anomaly of the bylaw.
Right.
But I'm struggling with the height. And I don't really see, I don't see the justification for an additional 0.5 meter there. And I'm wondering why you can't just keep within the bylaw.
So I think the client was trying to achieve a certain design with this house, and in part because there's not really any windows on the side. The point was to have this grand skylight that was on the top. I can point out that in our slide deck in our presentation in page 5, 6, and 7, we showed a number of examples of fairly tall And there's an example right there. There's another one there where you see that difference in height between structures. That's not an unusual thing in this
I get
neighborhood.
that, but I have no idea whether that complies with 13 meters or that exceeds the bylaw.
And
So
that-
my only point is, I'm not sure that you can accommodate what you're looking to achieve and stay within the height bylaw. So, for me, I don't have really any problem with the rest of the application. I get it, but I can't support the height variance. So, again, there's no question there, that's just a statement. So, anyone else have any questions?
So if it's of assistance, my apologies to interrupt. I was texting my client because obviously I can't make a decision
Right.
without instructions. My client has just authorized me, given the concern you've raised, to lower that, I'm gonna call it the chimney height, from 13.5 to 13 meters.
So you will then be eliminating 2 variances?
We would be eliminating the variance for overall height. I believe we would still need the main wall height variance.
Oh, because it's 10.5, so you would amend that to be 13 meters rather than 13.5,
That's correct, thank you.
okay? All right, any further questions? All right, let's take it into committee. Sabrina, I would just, before we talk about it, I just want to confirm, Sabrina, with you. The agent has suggested that we make, if we were to approve this, it be conditional. Just wanted your advice on that.
Sure, through you, Mr. Chair, you can include that condition that a consent application is approved, but the consent application will be refused. A notice will be sent out next week, and that notice is appealable.
Right, so they'd have to go that
That is
path.
the route, or they have that application go null and void, and they submit a brand-new application.
That's great, helpful. Yes,
But,
Phil?
to the Secretary Treasurer,
Yeah.
but if we don't include that condition, it's still the same thing essentially, right? Because,
It's still refused,
um,
notice goes out next week, and they appeal it.
no, but I mean, like, if we approve this application and we don't have a condition, they still can't build this without that consent, right?
That's correct.
Yeah. So it's
Well,
the-
technically, I guess they could if they didn't separate
Well, if they
the
didn't,
houses.
yeah, I mean,
Right,
they'd have to
could
shift
keep it 2
everything
semis,
over.
right, and still
Right.
have the same variances,
Yeah, okay.
right?
Yeah.
So if this is an approach to, if the germane part of this is to split the lots into 2 and have 2 separate purchasable or sellable lots, then that's what they want,
It's portions of the lot,
Yeah.
portions of the lot,
not
not the whole lot?
Not the whole lot.
Ah.
It's not a straight severance lot addition
to
from
me
front,
looks like-
front lot line to rear lot line.
That might be part of the issue, is that it's not a straight, you know, they could have severed it in a straight line and given a straight line to the other property, but instead they
It's the portion.
jogged it. Yeah.
Okay.
Sorry, through you, Mr. Chair, then for public record, variance number 1 is being removed,
Variance number
and
1
all
and
other variances remain as is.
Variance number 2 will be amended to have the height of the sidewall exterior main walls be 13.0 meters rather than 13.5. That's
Yep,
correct, okay?
and that's for 521 Brunswick Avenue.
Correct.
Okay.
Okay, anyone else have a?
Yeah, I was just going to, just because I like to be contrary, put in my contrary thoughts that, you know, the annex, having lived there for a long time, it does have really tall buildings, and 0.5 more for the sole reason of creating an architectural statement, because it's clear that that's what it is. It's just for creating an architectural statement. I don't take issue with it, following the approach of planning staff, which was to tie it to the elevation. So that was, but
Yeah, I get it. My only, the neighbors have concerned about height and
yeah.
massing, so it just struck me this would be a nice way to.
It is a compromise, but it's a compromise on something that I understand that they're concerned, but I don't know that their concerns, I don't know that the impact is what they imagine it to be. But But recognizing that the applicant has agreed to reduce a variance, obviously I accept it. But as I said, just to be contrary, I thought I'd put my
course.
contrary thoughts out there.
Anyone else have any comments? No? Okay, Phil, I'm gonna, since you and I have been chatting, it's either me or you, or it's over
Sure.
to
No,
you.
I'll now in the spirit of compromise, I will move to approve it as amended.
So approve as amended for 521 Brunswick Avenue, and then approve for 523 Brunswick Avenue.
Exactly, and even if the condition that the consent be granted is not strictly necessary, I think I'd like to include it just so that it's clear to anyone reading the minutes from this application. So I'd also add the condition that the consent be granted, whether however the Secretary Treasurer believes that condition is best worded, given that it sounds like the avenue is probably via appeal.
Okay, motion by Mr. Ghosh
And
to approve.
and I'd also include the community planning condition substantially in accordance with.
Well, now that we're changing the height,
There is one related to other variances though too, I
Yeah.
believe.
say again?
I believe there's.
They're relate, yeah.
Yeah, there's a second recommendation around variance 3 and 6, around building depth and rear yard setback.
Oh,
Yeah.
yes. Oh, okay, sure. I'll add that condition then to be substantially in accordance.
In accordance just with the site plan?
Site plan, yeah.
With the,
Site plan will capture it.
yeah. Site plan.
Okay, all right, everyone's got that? Okay,
Should we, friendly amendment, should we say revised site plan?
Well, the site plan isn't revised.
No, it's going to be though.
but we can't tie it to something we haven't seen, right? So if they're gonna revise in the future, we can't tie something that we haven't got before us.
Okay.
Yeah.
I love it when the Secretary Treasurer agrees with me. All right, motion by Mr. Ghosh to approve. Dina, were you seconding that? Sure. All right, second by Mr. Lombardi. All in favor? Okay, you have your approval. All right, we move on to item number 20, 118 Sheridan Avenue. This is an application to construct a new 2-story detached ancillary building for the purpose of a lounge and a storage area on the ground level and a loft in the second level. In the rear yard of the existing 2.5-story townhouse dwelling, this ancillary building will not be used for habitable space. The existing ancillary building in the rear yard will be demolished. The committee has before a copy of the minutes of the November 12th public hearing, a copy of plan of survey, site plan, floor plans and elevations, and a staff report from community planning.
Through you, Mr. Chair, we have the agent here in person. Please come up to the podium.
Good afternoon, sir.
Good afternoon, Mr. Chair. My name is Addison Milne Price. I'm a registered professional planner employed at Design Plan Services located at 87 Skyway Ave, Toronto.
Great. We don't have anyone registered to speak in this item, but since you came down, maybe just a quick overview of what you're proposing.
Absolutely, I'm fine with that. And there is a little bit of history here, so I'm happy to sort of get into that and preempt any questions that might come up. First of all, this application, it was before the committee just, I believe, a month ago, where it was deferred to address some concerns that forestry had. I'll note there wasn't a particular variance that forestry had any concern with. They were just wanting to ensure that we protected that tree to the rear lot line there. And I can confirm that through our discussions, we've come up with a plan that meets their requirements. We haven't changed any of the variances. We haven't changed any of the design of the ancillary building itself. We've just proposed helical piles to ensure that we're not going to damage that existing and quite large tree in the rear there. Also confirming, I have no issue with the proposed community planning conditions of approval. There's no intent for anybody to use this building as a dwelling unit. The intent is only for storage and for passive recreational use of the owners of the townhouse itself. Just in terms of the variances before you, they are quite similar to a previous approval on this property in 2021. I'll note that there's a few changes. The one that perhaps may jump out to you is the soft landscaping variance at 29%. And what I would like to point out to you is that this is a townhouse lot that is just over 6 meters. It's 6.1 meters in width in lot frontage. And that's significant because when you get below 6 meters, the requirement for rear yard soft landscaping is actually 25% instead of 50%, just recognizing that it's a proportional amount, and the smaller you go, a small change can make a big proportional difference. So what we're proposing is actually compliant with that 25%. What I'd also like to point out is if you look at the plans or the survey, both of the adjacent townhouses have a rear sort of addition that about matches the size of the rear deck in the existing yard. That rear deck is existing, and it does take up most of the area that would be used for soft landscaping. What I'll point out is if an addition instead were to be constructed there, the calculation for rear yard area and thus rear yard soft landscaping would then change. There would be a smaller rear yard and thus a smaller amount of rear yard soft landscaping. So in large part, this variance for soft landscaping is really about the peculiarities of this existing lot. The fact that it is a small lot and it has this sort of existing deck. But that deck does allow for some amount of infiltration of water. Of course, not exactly the same as soft landscaping, but it is significantly better than if an addition were to be constructed there. With respect to the building itself, the setbacks that we're proposing are I think, quite minor. They're similar to the existing shed that was approved previously. In fact, I think that the variances are almost identical to what was approved in 2021. And the variance for height, we're asking for an additional 5.19 meters, where 4 is required for ancillary structures, as well as 2 stories. What I'll point out is, in terms of privacy, there's only windows facing the subject property. On all of the elevations, you can see there are no other windows. There's also a nice set of renderings down below the package you can see. And while there is no intent to have this be a dwelling unit, as I'm sure you're aware, garden suites are something that are permitted all throughout the city. Because of that, it's somewhat difficult to find ancillary buildings that are within the range of 4 meters to 6 meters in height, because of course that's a permitted height as of right, even on this lot that's permitted. But there are actually examples in this neighborhood of ancillary building, at least one ancillary building that has a second story at 11 Middleton Street. That was approved in 2021 as well. So this type of building, it is certainly unique, but it is also not without precedent in the neighborhood. There have been no concerns from any internal department or external agency, nor has any member of the public raised any concerns with this. So if there are any specific questions about the variances or the proposal, I'm happy to answer them. Otherwise, that concludes my presentation.
Great, thank you. Panel, any questions? None? There you go, thank you. Okay, we're in committee. Anyone want to start? Phil, you're always my default guy.
Well, I was going to challenge someone else to.
No, you're.
I have. I know that particularly for you, Mr. Chair, the idea of having an ancillary building with a second story and a height variance just for storage is not sort of the trade-off that you'd expect in a laneway. We had that discussion earlier today, and I've heard it before. I take a different view and think, a little more variety on laneways is not such a big deal. So to me, I find it approvable. There's not much to the application beyond that, in my view. Either one views that as a minor change, or one doesn't, and to me, both views are reasonable. The rest of the variances, it's a slightly, the floor area of the ancillary building being larger has to do with it being 2 floors as well. So it really comes to the same thing. The only sort of discrete variance is the soft landscaping, but I think that was adequately explained. So I find it supportable, but I can understand where others may not.
Okay. Anyone else? Not
So-
hearing else. I mean, you're right. I just didn't want to sway my panel members one way or the other, but I do have strong views on this.
So I'll move a motion, and we'll see how it goes down. I'll move to approve the variances for the reasons I gave in my explanation. It is creating a larger laneway use, but I think our laneways are evolving in that direction. So to me, I viewed the impact as minor.
Okay, motion by Mr. Gauche to approve, seconded by Mr. Bissonnette. All in favor?
Are there not conditions?
Oh, are there conditions?
Forestry.
There's forestry too, subject to forestry too.
Again, I've got my notes that planning has asked for substantially in accordance with.
Did it?
I saw that in the.
Through you, Mr. Chair, yes, I've seen that as well.
Oh, it's in the
Supplementary.
Yes, so I would gladly add that as well. Given that it's planning staff's recommendation, it makes sense. So, subject to planning condition and forestry too.
Okay, motion by Mr. Gauche with those conditions, seconded by Mr. Bissonnette. All in favor? Opposed? Ms. Plaitzer and myself are opposed, but that motion carries. The application is approved. Okay, we move on to item 21, which is 442 Harvie Avenue. This is this a consent for seven? No, this is just an application? Is there a consent? Is there a consent on this one? No. Says consent requested? All right. This is just an application to construct a new 3-story fourplex dwelling with a front integral garage, front, second, and third-story balconies, and rear ground floor, second-story, third-story balconies with connecting exterior stairs and platform landings, as well as a rear basement walkout. Also to construct a new 2-story ancillary building containing a garden suite in the rear yard with a second-story balcony. The existing 1-story detached dwelling and detached garage in the rear yard will be demolished. There will be a total of 5 residential dwelling units on this lot. Committee has before a copy of the minutes from the November 19th public hearing. We have copy of plan of survey, site plan, floor plans, and elevations, revised site plans, floor plans, and elevations received December the 3rd. Red line public notice from the agent, a revised zoning waiver, covering letter from the agent, staff report from Urban Forestry, and correspondence and concern from 448 Harvie.
Through you, Mr. Chair, we have the agent online to speak, and we have one registered speaker also online.
Okay. All right, if we could have the agent.
Good afternoon, Mr. Chair and committee members. My name is Sabal Methno from QBS Architects, 14 Crofton Road, Toronto, Ontario.
All right, ma'am. We have somebody who wants to speak to this item, so we'll need a presentation, please.
Absolutely. So we are here before you from the deferred hearing of November 19. We went back to the drawing board and we contacted both neighbors. We made improvement to the application. Our application is to propose a fourplex, 3-story fourplex with a rear garden suite. We were able to connect with the neighbor at 448 Harvie and we were able to satisfy his concerns. So they withdrew their objection. We increased the side yard setback from 0.19 meter to 0.6 meter, and they were satisfied with that. We have eliminated the soft landscaping variance. So now we don't have any soft landscaping variance. We have added privacy screens on the sides of the balconies that are looking on actually the neighbor on 4480 Harvie. We tried several times to connect with the owners of 440, but we were not able to connect. Like, we sent them the email of the revised drawings as well. They have not responded to our request to meet with them to discuss the application. However, we took it upon ourselves to improve the application as we speak. We have eliminated the platform variance on the garden suite as well, and the rear yard setback on the garden suite now only applies to the second floor minor cantilever. I would like to mention that the rear of the property, there is a cemetery, so there is no concern of overlook or anything. If committee member staff is just kindly share the drawings, because I want to point out also we have changed the walkout, which is basically the entrance for the basement unit. So now we have a completely enclosed stairs that's accessed from the back. Only one side entrance of the ground floor unit is from the side that is facing 440 Harvie Avenue. Also, we recessed the windows, which you see in the bubble, to enhance like the privacy on both buildings. We don't have any height variance. We don't have any FSI. We will be seeking front yard setback variance, which is basically the existing, where the building existing was. So we are seeking that variance. Side yard setback only on the north, 0.2 meter. And as I said, we eliminated soft landscaping variance and one variance for the garden suite, which is the rear yard setback. The angular plane will no longer be applicable because the bylaw changed. I'll be more than happy to answer any questions committee members or the neighbor has.
Okay, thank you very much, ma'am. Let's
Sorry, through you, Mr. Chair, just one point of clarification. On the red line notice, the purpose of application has been amended. Can you tell us what the change is?
The change is like it's still the same. It's the fourplex with integral garage.
Yes.
And
I just want to confirm that the purpose of application that was sent out with the notice is correct, that we don't need to make changes to that.
No, that is correct.
Okay.
It's just like we just rewrote it. That's it.
Okay, but it's the same. Thank you.
Yes, it's exactly the same. Fourplex and a detached garden suite.
So if you're okay, we'll just keep the wording that was in the public notice.
Correct.
All right, we have someone speaking on this item?
Yes, through you, Mr. Chair. We have Lucy. Hi, good afternoon, Lucy. You've been unmuted.
Hi, good afternoon. I am the daughter of the owners of 440 Harvie Avenue. They are south.
Sorry,
of
Lucy,
the home.
did you state your name for the record?
Oh, sorry, Lucy Arruda.
Okay, thank you.
Arruda.
All right, ma'am, go ahead.
Yeah, so my parents are the owners. They've been the owners for 44 years. So they are the house right beside the building that they want to build. It's with the driveway, so they're right there. So I do have some concerns. My first concern is we still to this day haven't received a written notice that this is even happening. The only time my father knew that this was happening was somebody from their party approached him to sign a form basically okaying for this to happen. He does not speak English well, so he didn't sign it. That's when he mentioned it to me. I looked into it, and that's how we found out that this was going on. There was no signs in front of the house. I know that last meeting was deferred because they had to put a sign. So the sign is up there now. My parents are elderly. My dad's almost 80. My mom is not well. Basically, the home is like a retirement home for my mother. She cannot leave the home. She is there 24/7. We have PSWs. We have nurses that come to the house. So I am concerned with all the construction and all the noise that will be happening, all the extra tenants that will be, instead of them dealing with two tenants, two families, they're going to be dealing with multiple tenants. Also, too, I am concerned with the property is very narrow. No one has come to, are they going to take pictures of my father's property to make sure if there's any damages that it's going to be fixed. We're talking about an old foundation the home is built on. Concerns with the heavy machinery and things like that. Drainage, the runoff flowing into the property. That area is already very well known to basement flooding. And unfortunately, my father has experienced that a few times. So with the lack of greenery, and like I said, drainage and runoff, parking. Currently, Harvie Avenue is no parking on the streets. So I'm not too sure where all these residents are going to park their cars. We are not that close to TTC. As I used to live there, it's a good walk to transit. I know the Eglinton station's going up, but that's still quite a bit of a walk. And then there's Caledonia, which is not always feasible. And what other points do I have here? Privacy. My parents' bedroom window is right there. It is already kind of not private because, like I said, it is narrow. So now with the new build being wider, there's going to be multiple windows on that side facing them. Little concern for their privacy. All the entrances are on that side of the house too. So all these people that live there will be using that side of the home, which is, like I said, their privacy with their windows and things like that. And I think that's about all my concerns that I have with this being built.
All right, ma'am. Thank you very much. Panel, any questions of the speaker? No? Thank you. We have one more speaker, do we? Oh, David Riley? Or
For you,
Riley
Mr.
David?
Chair, David Riley has withdrawn
Oh.
and will not be speaking.
All right, thank you. Okay, we'll have the agent back then.
Thank you, Mr. Chair. So I will take Lucy's points one by one. As I mentioned, I have personally sent Lucy through email, and the counselor was copied on the email exchange for the proposed improvements to the drawings. We have not heard back from her. The sign was posted as per the bylaw requirement, and pictures were provided. In terms of, also I forgot to mention that we have 4 letters of support. We don't have any side yard setback between our, the property and where Lucy's parents reside. So we are 1.2 meters, so within the allowable bylaws. Despite that, we tried very hard to enhance the privacy, as I mentioned. So we relocated the basement walkout. It's completely enclosed now. We pushed the windows in. So if staff could kindly just refer to the maybe basement plan, which is the next sheet. So it will be able to demonstrate so that would be, that's okay. These are the area plans. So the entrance to the basement would be from the back, and thank you so much. So we recessed the windows in the basement to enhance the privacy and the entrance from the back. To enhance that, we introduced privacy screens on all balconies facing 440. And they are labeled and mentioned on our drawings as well. Front and back. Despite there is no requirement for parking by the city, we have one integral car garage within our proposal. When it comes to soft landscaping and drainage, we have zero, we don't have any variances for soft landscaping, so we comply with that. And when it comes to drainage issue, this item will be handled by the city when we submit for a building permit. I'll be more than happy to answer any questions.
All right, thank you, ma'am. Panel, any questions of the agent? None? I don't have a question, I just make an observation. I've said this to other applicants who have brought forward multiplex applications. The renderings that you've submitted are helpful. They show your application in a very positive light. But I would suggest to you that positioning your your proposed structure in a field with trees around it isn't exactly fair to the neighbors. You can certainly submit this, but I think going forward, it would be also helpful to show a rendering of your application with the actual buildings next to them so that we and the public can see how your proposal fits in with the surrounding neighborhood. Okay?
Noted.
Thank you. All right. I'll take this into committee. Dino?
Thank you, Mr. Chair. I think this is an appropriate proposal for this particular lot and neighborhood. I'll call it a detached houseplex, which is what community planning wants us to call it. In reality, I think we've only really got 3 variances that we have to deal with because variances 5 and 6 for penetration of the angular plane have already really been taken care of if this were considered current and reviewed by zoning bylaw currently because those requirements have been eliminated. So these are supportable. This is the type of development that council has been considering, and the variances are before us are minor in nature, and I would support them. I would put a motion forward.
Anyone else want to speak to this one?
I'll just note, Mr. Chair, that this neighborhood is experiencing this type of change with increase in density and larger homes on these lots, and it's a prime area for this type of density. So.
And there's this cemetery, open space in behind, right? Yep, I agree. All right, Dino, did you want to make a motion?
Sure. A motion to approve, subject to urban forestry conditions, I think 2 and 3 are recommended.
As amended?
Amended, yes, absolutely amended.
Except for the purpose, we'll keep the original purpose?
Yes.
All right. Motion by Mr. Lombardi to approve with those conditions, seconded by Mr. Bissonnette. All in favor? You have your approval. Thank you very much. Move on to item number 22. 2106, 2108, and 2112 Dundas Street West. This is an application to alter the existing 3-story mixed-use building containing 3 commercial units at grade and 4 residential dwelling units above by constructing a rear 2nd and 3rd story additions with 3 second-story rooftop terraces and 3 third-story balconies above the rear 1-story portion of the building to accommodate an additional 9 residential dwelling units. 1 existing commercial unit will be converted into 2 commercial units, and 1 existing residential dwelling unit will be converted into 3 residential dwelling units. There'll be a total of 4 commercial units at grade and 13 residential units on this lot. Committee has before us a copy of the plan of survey, site plan, floor plans, and elevations, 4 photographs of the subject property, covering letter from the agent, a rental housing demolition conversion declaration use and screening form, and an advisory report from Metrolinx.
Through you, Mr. Chair, we have the agent here in person to speak, and there are no other registered speakers for this item.
Okay.
I don't have to make a presentation if you prefer it that way.
Well, let's do, tell us your name and address and we'll consider that.
It's Bernard Watt. I'm the agent and architect.
All right, sir.
36 Witchwood Park.
Thank you. It's just the angular planes, is it?
Yeah, that's it.
Okay, I, first of all, thank you for coming down. We almost hate to not make you give a presentation if you come all this way in this snowstorm, but I don't think we need one. Maybe what we'll do, we'll go to questions, but is there anything you'd like to share with the panel before we do that?
Not really, no.
Okay. Any questions? Look at that. No questions. All right, we'll take this into committee. Quite a minor application. Dino?
Yeah, I'll note that this lot is within the Dundas West protected major transit area, approved area, and it increases the number of residential units. And so I'm prepared to support this because it meets the 4 statutory tests. It will also increase the rental and affordable housing options in an area that will benefit greatly from that.
All right, do you want to turn that into a motion, sir?
Yes, I would move to approve the application and the variance, the single variance, subject to the Metrolinx condition.
All right, motion by, did you want to say something?
No, through you, Mr. Chair, I was just gonna say it's the warning condition.
Just the warning,
right?
just the warning? Oh, I
Yeah,
thought it was a
that's fine.
condition. Okay.
No, it is. It's just, they list the easement
Yeah.
condition as well, the environmental easement, which we typically don't impose, so it's just the warning.
Okay.
Yeah.
Okay. All right, motion by Mr. Lombardi to approve, seconded by Mr. Bissonnette. All in favor? Thank you for coming down. Do you have your approval?
Yep.
Is this your declaration? All right. Okay, we move on to item number 23. 523 Delaware Avenue North. This is an application to alter the existing 2-story detached dwelling by constructing a rear 2-story addition with the ground floor decks and chairs and stairs. The existing rear 1-story partial addition on the dwelling will be demolished. Also the ancillary buildings, a garage and a shed in the rear yard will be maintained and unaltered. Committee has before it a copy of the plan of survey, site plan, floor plans, and elevations, 4 photographs of the subject property, presentation materials from the agent. We have staff report from community planning and correspondence and support from 525 and 543 Delaware Avenue North, and correspondence in opposition from 521 Delaware Avenue North, and a 6th signature petition in opposition from owners occupants of 532, 317, and 520 Delaware Avenue North.
Through you, Mr. Chair, we have the agent online to speak, and for this item, there is 1 registered speaker here in person.
All right, thank you. Okay. Good afternoon.
Hi, good afternoon. Thank you
Name
for
and
having me
address, please,
today.
sir.
Yeah, my name is Kyuta Kim. I'm an agent, and address is 2347 Kennedy Road in Scarborough.
All right, sir. We have someone who wants to speak to this item, so we'll need a presentation, please.
Yeah, of course, yeah. Basically, the property is a existing 2-story single-family dwelling with also existing 1-story rear addition. We are requesting a relief to permit the construction of a new 2-story rear addition and a new ground floor deck. The proposed work is intended to provide additional and functional living spaces to accommodate the owner's growing family and improve the overall usability of the house. So we have 4 variances in front of us. So I'm going to break down the listed variances, but the number 1 variance is the main concern from neighbors. So basically, existing soft landscaping is 33.5%, which is 40.7 square meter, whereas we propose 26.07%, which is 31.7 square meter soft landscaping. There is around 9 square meter different, which is 7.43%. The reason why the existing soft landscaping is reduced because of the new deck, basically not the new rear addition itself. So as the new two-story addition is entirely within existing concrete pad and the footprint of the existing one-story rear addition, there's a less likely to affect the existing drainage system. But I closely communicate with the city planner to mitigate this. We offer permeable material underneath the new deck for a better drainage system. So in fact, there's no reduction of existing drainage system. Only the about 9 square meter of grass will be turned to a new deck with permeable material underneath, which we discussed with the city planner as a solution. And for the next page, as you can see that the grading shows that the slope is towards front and back for stormwater runoff. Probably it's less likely to go over the adjacent neighbor, especially towards 521 Delaware Avenue. And given the fact that this property owns a mutual driveway on the north side of building, this area is covered with a hard landscaping. This makes the total rear yard area enlarged in the calculation and hard to achieve minimum 50% of soft landscaping requirement. This access is no longer used, but requirement. This access is no longer used, but still it is legally binding on this property. Yeah, as you can see, there's a laneway in the back, but probably back in the day there was no laneway, so that's why this easement right of way was established. And then regarding the building itself, we are proposing 15 feet long two-story rear addition, which includes the length of existing one-story rear addition, which is 10 feet 2 inches, and then we are just adding 4 feet 10 inches extension. And then top of that, we are proposing the 6 feet depth of the new deck. So, so the owner of the 523 Delaware Avenue actively communicated with the neighbors to explain the development and situation, and we really fully engaged in the conversation with neighbor for this matter. So as you can see, the variance number 2 and 3, 4 basically is minor. Variance 2 is for new platform setback. It's not the rear addition itself. It's triggered by new deck. So we have only 4.5 inches difference from the required.
So I'm sorry for interrupting here. You're breaking up on us. Are you close to your phone?
Only 4.5 inches difference from the probably my internet might be unstable, but can you hear me now clearly?
What he's saying, I can't make out
anymore.
Is it on our end or their end?
Can you hear me clearly?
Yeah, but a little bit better. You've been breaking up for about the last few sentences, so.
Sorry for the internet connection.
Since you moved on to variance 2.
Yeah, so if you start back with variance 2.
Yeah, variance 2,
we'll
3,
give you a little
4,
more time.
Yeah, variance number 2, 3, 4 is such a minor variance. It's very small, like a difference when it comes to figure. So I would say most likely variance 1 is the important that we gotta dealing with. And then I know that the 521 Delaware neighbors, they complain about the blocking their view and the sunlight. So that's why we did some path study, which during the main sunlight hours, it wouldn't block, it wouldn't interrupting their sunlight time in their backyard. So basically, overall, the development is aligned with the the neighbor's character, and then there's no expectation of any adverse impact. Yeah, it's pretty modest and then reasonable size of the development. So respectfully development. So we'll still way to approve our proposal. Thank you.
All right, sir. Thank you. Anyone have any burning questions? Can I just clarify, are you proposing a single-car garage or a two-car garage?
We are not proposing any like a garage. The garage is existing.
Oh,
We
it's
are
existing.
proposing
Okay.
the two-story rear
I saw
addition.
some reference in your presentation to a two-car garage, but that's okay. All right. We have someone here. Hi. Come on up. Okay. Name and address, sir.
John Kilty, 521 Delaware Avenue North. And before we begin, if we could have our detailed direct neighbor opposition letter available, as well as the applicant's presentation. I'll be referring to both. If you could start with page 2 of our letter, the direct impact. Regarding the test number 1, the variances aren't minor. The numbers may not seem big to you, but they're important to us, especially failing to meet the soft landscaping requirement of 50%, which the applicant has at 26%. On page 2 of our opposition letter, you can see where we are already experiencing water seepage into our 100-year-old masonry basement and next to the wall that would be extended. The applicant's, on page 3, the applicant's presentation states that constructing two-story rear addition will not cause any drainage issues. This is not accurate. Please see the picture on the right. The new rear extension will more than double the existing surface area shown with that photo on the right, meaning that snow and rain that would otherwise blow over the existing structure would hit the new southern wall and drain onto our property, pool against our house, accelerate soil saturation, put further water pressure on our 100-year-old foundation. You can see this is already happening with the photo on the left. Where that water pressure then goes down directly to our basement, causing the seepage that you saw on the previous page. Also on page 3, regarding the deck. Respectfully, the staff report's recommendation for permeable materials does not support the intent of the bylaw, which is explicit as a defined term found on the official plan and guidelines webpage. From the glossary section, soft landscaping, an open, unobstructed area that supports the growth of vegetation such as grass, trees, shrubs, flowers, or other plants, and that permits water infiltration into the ground. The recommendation did not cite any clause or exception to this definition. Clearly, permeable material underneath the newly proposed deck doesn't qualify, as is neither open nor vegetation. The reality is that the hard surface is a wood deck that impedes water drainage and risks draining further water onto our site. Please go to the applicant's presentation, pages 6 and 7. In terms of context, the examples the applicant cites here are dissimilar to the immediate context between 523 and 521 next door where we are. Only 28 centimeters between us, as you can see there. A historical quirk similar that it contributes to the pressure on flooding. The highlighted photos show that all the properties have functional side yard setbacks of at least 1 meter compared to our 28 centimeters. Some of those have. You're not on the right page. Can we pause for a second? I asked for the applicant's presentation, page 6 and 7. Okay. The highlighted photos by the applicant shows that the properties have functional side yard setbacks of at least 1 meter compared to our 28 centimeters. And the development of the back of the houses are relatively uniform, several with single-story extensions, 525, 527, 529, and 541. Demonstrating the flood risk, the highlighted properties lack front and backyard soft landscaping for drainage. As you can see, there are several with zero soft landscaping, and we are to the south of them, as well as some of the people who signed the opposition signature are also to the south. No previous decisions from the Committee of Adjustment relating to backyard soft landscaping variance exceptions are cited by the applicant. In my review of previous decisions from the past 20 years, I did not find any decisions related to acceptance variances of soft landscaping for single dwelling homes on Delaware Avenue North. back to my opposition letter on page 6, please, where you can see the significant impact on light and livability from the planned extension. This is due to the footprint of the rear extension, which is the primary reason for failing to meet the soft landscaping requirement. So this is our son's bedroom, but it'll be turned into a dark box with a 15-foot wall blocking the little light that comes in. I'm not talking about shadowing or shade. We have little light, and that's ambient light that comes in. And a 15-foot wall is going to be a major impact to our quality of life. We did not budget for building a new window or the insulation that would be needed to keep a room like that warm. The proposal is not desirable or appropriate for the area. Pages 13 and 14 of the opposition letter. There are 39 properties on Delaware Avenue North built as row houses or physically connected in rows of 3 or more properties representing 35% of the street. If everybody were to act in this way, social cohesion would fall apart due to everybody just doing the negative impacts that they want to do. And the first sentence of Chapter 3, the official plan states that building a successful city means making choices that improve quality of life. I've demonstrated that there are negative impacts with this development that impact our quality of life. Given that the staff report included conditions, I'd like to include that the materials, if this were to go ahead for some reason, that the materials on the extension wall that would block our window, we would be consulted on those materials to mitigate the impact, as well as reduce the deck for privacy to a ground level patio, and with the barbecue to the north, I guess I'm at time.
All right, sir. Thank you very much. Panel, any questions of the speaker? No, thank you very much, sir.
Thank you.
All right, we'll have the agents back.
Yep. So, yeah. So the neighbor, bring up the soft landscaping. Yeah, basically, on this street, we have we are the one who has a decent amount of the soft landscaping in front yard and then backyard. Yeah, somehow we have a minimum 50% of the soft landscaping requirement, but considering the fact that this neighborhood, like a character, it's less likely to have the enough some landscaping because of the presence of the garage and the laneway in the back. So it is hard to achieve the soft landscaping requirement. So that's why we offer the permeable material right below the new deck. And whatever the existing issue they have it's not because of our development or the existing development. Yeah, we have a proper slope for the drainage regarding the grading, and as they said that their foundation is like a century old foundation, so it may need a repair of the waterproofing or membrane, something like that. It's not directly relevant to our development.
All right, questions, Phil?
So, building the rear two-story addition, your variances barely even touch on it, to be honest. When I look at the variances, the variance that does concern me is the one that we've been speaking about, which is the soft yard landscaping. Requirement of 50%, you're doing 26%. It's, close to half of what the requirement is. I understand the compromise with planning, which I do take note of, is that this will be about the same amount of drainage as you have right now back there, so long as you make the area under the deck permeable. But the reality is, when we do have applications before us, especially with soft landscaping, there is a greater recognition now than I think there was in the past about how important drainage system is in the city. And the zoning is there for a reason, so what we like to see is an improvement. And what I'm not understanding is why you can't improve your soft landscaping. I don't quite get your explanation as to why you can't remove some portion of this driveway that's in your rear yard. So maybe you can explain why you can't do that.
So basically, as I said, yeah, there's a mutual driveway which we cannot touch on. Yeah, so we gotta keep it as it is. Yeah, for that driveway. Yeah.
But the mutual driveway has a fence running down the middle of it right now. Is that not correct?
Now, yeah, it's an existing condition actually, but technically it shouldn't be, of course. But we talked to the neighbor, the 525 Delaware. They claim that it's existing for 15 years, and it's no longer used as a shared driveway.
So it can't be used as a shared driveway anyway, at the moment as an existing condition, recognizing that the right of way is there and you might have to provide vehicular access. Sorry, were you hearing me? Because we were speaking over each other.
Sir, Phil,
At this moment, I'm not
hang on a
saying
sec,
anything,
sir. The member's not finished his question here. So, Bill, you want to continue?
Yeah, no, and I wonder.
I'm not saying anything. Yeah.
Sir, are you talking to someone else? Okay. Just hold on a sec, sir. Phil's going to ask his question.
Would it be possible to remove the driveway that's in the rear yard and replace it with some sort of permeable material, recognizing your concern, be it permeable material that's appropriate for vehicles like a pea gravel or something else?
Okay. Sir, did you?
Yeah.
Have you heard?
So basically you want to like remove, just change the driveway in the backside of the lot, like into the soft landscaping, right?
Exactly. I think, from the rear wall of your client's, the proposal of your home, onwards, behind that, I don't see why you can't remove the existing paved condition and change it to soft landscaping in a way that respects whatever you believe.
What about the area behind the shed, Phil? Are you thinking of that as well? That looks like it's hardscape right now.
Sure. I'm sort of asking the question because maybe there's a reason to keep some of it as hardscape if that's off the laneway and where a car is parked, but maybe not. But we seem to have a poor connection with the.
Sorry, through you, Mr. Chair. We do have the homeowner here. Maybe they can
okay.
come up and answer any questions.
Yeah, we're having
poor connection.
So, sir,
come up to the seat there, please.
Maybe you just give us your name.
Hello, my name is Michael Bush. I live at 1023 Delaware Ave North, also at 793 Ossington Avenue. So the issue at hand we have is that prior to, I'm not sure when the shared laneway in the back of the house was built, but between our house and the house to the north of us is a driveway that has since been, towards the back of it, a shared fence has been erected. That shared laneway is actually all part of our property, and our property line actually goes about 3 feet into our neighbor's backyard as well. We were told we are unable to change any of our hard landscaping along that shared fence because it was originally deemed as a shared easement to access the back parking lot. And so the pavers that are along that wall, we were told we weren't able to move those. We are completely open to removing those because that is not functioning as a driveway. As for these, you could refer to it as a secondary parking beside the shed in the back. We are completely open to removing the cement and replacing it with gravel or any sort of permeable green landscaping.
So I'm not a real estate lawyer, so I don't know all of the ins and outs of rights of way, but my general understanding is you have to be able to, allow access to the property, but access to the property for the use of, vehicles traversing it doesn't mean that it has to be asphalt and can never be anything else. In fact, sometimes these accesses date back to when people were using horses. So I have no concerns with putting in a condition that shall be replaced with some sort of permeable material. I don't think that's going to put you in any sort of legal jeopardy. To me, that would improve your application to a point that would make it much more supportable. Would you be agreeable to that I say anything behind the rear wall of your home in that driveway space be turned into a permeable material?
So ideally, the existing external garage we would like to keep. What could be thought of as a secondary parking space next to that, we are more than happy to replace.
Oh, sorry, I didn't mean to take down your garage.
Okay.
No, yeah.
No, we are more than happy to accommodate and change.
Yeah, as Phil points out, it would be very difficult for this panel to approve an application which is 50% of what's being required. I mean, that is pretty inconsistent with what council and the city is trying to achieve. If you could, as Phil says, if you are open to changing part of that right-of-way into something more permeable, and the right-of-way doesn't go, does it go all the way right back to the laneway, or does it go roughly to where your shed is?
It goes to where that shed is.
Okay.
And then there is a fence that's there, blocking effectively our backyard to the laneway.
Right, so you have a garage and you have, for lack of a better word, a parking spot there, so you could put two cars. So I think what Phil's saying is if you were open to altering the ground cover in the right-of-way, I guess to roughly where your fence is anyways, to the end of the right-of-way, and then that area behind the shed where you do parking, if you could replace whatever's there with something that's permeable, that would be much more desirable.
Okay.
Sabrina, would we be okay, if the panel is so inclined to approve this, would we be okay just putting a condition to that effect, or would you like to have it recalculated?
Through you, Mr. Chair, if the applicant is able to provide us with a recalculation?
That would be preferred.
Yes.
So here what she's saying is that we can give you a little bit of time. If you could calculate the rough square meterage of those two areas, and then we can amend the variance request to whatever that tops out to. It may in fact even eliminate that variance. So if you and your agent, we can stand this down. If you and your agent wanted to go and calculate that, and then come back to us, that would be the preferred option.
And to be clear, what we would ask is for you to calculate for the area that's on your side of the fence, recognizing that some of your property is kind of outside of your control. We're not going to impose something on you, so calculate that part.
Okay. We need another microphone.
Thank you. Thank you. So just so I'm clear, there's two components for this recalculation. One is the square meters of if we turn those two pieces on our side of the fence to soft landscaping, what is that addressable size? And then also if we're, changing the denominator denominator of this calculation to not include the 3 feet of the neighbor's backyard that is technically part of our property, but is on their side of the fence, right?
That sounds about right.
Okay.
Yeah, I think it's just one calculation, though, of changing to soft landscaping the part of that driveway that is on your side of the fence, plus the parking at the rear.
Okay.
What's that square?
Yeah, so it's basically variance number 1.
Okay.
Right, so there's what the standard is. Right now it reads in this case 26.07 and bracket what the square meterage is. What we'd like you to go back and do is give us 2 new numbers.
Okay.
Okay?
Okay.
Okay, so we're on item, you're 23, we go to 26, so you've probably got about 15, 20 minutes.
Thank you.
Okay? I think I'm being optimistic.
Through you, Mr. Chair, we're going to get Ryan back into the room. We can probably deal with items 24 and 25 together.
Right. Okay. All right, you'll have to bear with me while I read both into the record. Item number 24 is 1095 to 1111 Danforth Avenue. This application is to alter the development standards for a new 13-story mixed-use purpose-built rental building containing commercial on the ground level by increasing the building heights and reducing the number of short-term bicycle parking spaces on site. A related site plan application is approved with conditions. There will be a total of 293 residential dwelling units on this lot. Committee has before it a copy plan of survey, site plan, floor plans, and elevations, 4 photographs of trees on the subject property, covering letter from the agent, an arborist report, presentation materials from the agent. We have site-specific zoning bylaws affecting the subject property, staff reports from transportation review, from TTC, and from community planning. We have correspondence and support from the Theatre Français de Toronto, pardon my French. All right, and I will also read into the record item number 25. We'll combining the two. Item number 25 is 1117 Danforth Avenue. This is an application to alter the development standards for a new 14-story residential rental building by increasing the building heights and reducing the outdoor amenity space on site. A related site plan control application is approved with conditions. There will be a total of 108 affordable rental housing units on this lot. Committee has before it a copy of the plan, of survey, site plan, floor plans, and elevations, 2 photographs of trees on the subject property, a covering letter from the agent, an arborist report, presentation materials from the agent, site-specific zoning bylaws affecting the subject property, and staff reports from TTC and community planning. All right, sir.
Through you,
Afternoon.
Mr. Chair, we have the agent here in person, and we have 1 registered speaker here in person as well.
In support or opposition?
In support.
In support, okay. All right, sir, good afternoon.
Thank you very much. Hopefully this will be quick. My name is David Mackay. I'm a registered professional planner with MHBC, 7050 Western Road, Suite 230, Woodbridge, Ontario, L4L8G7. I'll start with the 1095 to application. As noted, this application was approved by council in 2024. Since that time, our client has a nonprofit theater, Theatre de Français Toronto. Pardon my French as well.
Badly as I did.
Probably, yes. And so that has really necessitated the variances that are before you. Obviously, because of the theater and their height requirements, that has pushed up the building slightly to accommodate for the floor-to-ceiling heights. So they're in the basement as well as the first floor and then the second floor. Part of the variances for the mechanical equipment is for, and the increased height there is again for their electrical loads and whatnot for the theater, and that's pushed up again the mechanical components. And then lastly is the ground level, the residential units. So those are on the second floor of the proposal, and on that floor as well is the administrative offices and back-of-house components for the theater. So technically, it's a non-residential use on the second floor adjacent to residential, which was permitted on the ground floor as long as we had access to one of the streets for those residential units. Obviously can't do that because it's up in the air.
Is there separation between the two?
There is corridors and whatnot and separations within the building in terms of the various doors and exiting and whatnot.
Right, okay.
So, so it will be a contained unit, a contained component versus the residential component. So those are the relief there, and then the bicycle component, again, to fit the theater and all the requirements in, we can't provide the short-term parking spaces indoors that we had before, obviously because of the limitations along Danforth in terms of the walkway and whatnot and the size. We can't put additional parking spaces in the right-of-way, so that's why we're seeking the relief. And as noted, transportation staff are supporting that, provided there's the bicycle cash in lieu payment is made, which our client is acceptable of. So that deals with those variances, and I'm happy to answer questions now on that,
No,
or
why
go to the
don't you
next one.
continue on and
Great.
do the other one as well?
Great. So again, the second application, these two projects were designed and approved at the same time by council. So this is for a 108-unit affordable project by Neighbors Community Housing. And again, it's under construction, and as they were going through the construction detailing, there was a need to increase the height to address some of the further details relative to mechanical, electrical, and whatnot, and the mechanical penthouse component. So that really deals with the two height variances. And then the last variance dealing with outdoor amenity space is an odd one in that we went through the process in the rezoning application, and it was through the building permit review that it was recalculated in terms of the area by the examiner. And we're short by 5.4 square meters, but the design itself has not changed at all. So it's just really how it was calculated by a new examiner versus the previous review through the zoning process. So really no changes. We are still providing good quality space there, and we meet the overall requirement of 3.7 square meters. It's just the switch between indoor and outdoor that is being modified slightly.
Okay. All right, thank you very much, sir. Questions? There are no questions.
Thank you.
Clearly, now we have someone here that wants to speak in support. Afternoon, sir. Or
Yes, good
evening.
afternoon. Well, it's technically evening now, yes.
Technically evening, yes, it is.
My name is Peter Martin from 73 Osler Street. I'm the Housing Solutions Manager for the Toronto Alliance to End Homelessness. We have an MOU with the city. I work with the Housing Secretariat on policy and programs. And I'm here, as I'm sure you can guess, to support this application for a consent for minor variance. The geothermal mechanical energy system, which is the reason for increasing the height, is going to make it easier to decrease operational costs, which is really important in this type of building. It's also consistent with the Toronto Green Standard. And in terms of to keep the height the way it is now, with that change to the energy system, without the variance would require decreasing the height of the rooms. And we don't want to do that, obviously, because we want to provide, Neighbors wants to provide really good housing for the people moving in. And I just want to point out that with regard to the CMHD definition of reasonable housing, one of the points there in terms of adequate housing is that the housing meets basic standards of condition and size. And I think it's really important that when you're having housing for people who are previously homeless, that it be the best possible housing available. And I'd like to point out also that if you approve this, give consent to this minor variance, you're approving the rooms as they were approved by City Council in 2024. when they approved the zoning bylaw amendment. I don't have to tell you that this is in the middle of two transit-oriented community, major transit station areas. So keeping the density high is important. And the last thing I'll point out is that this is actually a minor variance. It works out to 4.9% variance from the approved height. And as I'm sure you all know, with both Bill 17 that's now come out is going to have regulations that allow for as-of-right variance of about 10% for setbacks. The new Bill 60 that received royal assent November 27th wants to do the same thing with building height. So I think taking into account the intention of the province with regard to the provincial planning statement, with regard to these changes, with regard to as-of-right variance, and the other things we've said in terms of it being consistent with the neighborhood, I think that this is a request that would fit with the four-part test that is before you. And unless you have any questions, those are my submissions.
Great, thank you very much, sir. Panel, any questions? The 108 affordable rental units, are they one-bedroom, single, or what configuration?
It's actually
are they?
really great. I cut that because it's late.
Okay.
It's a range.
Okay, so it's for families too,
It's
presumably.
2- and 3-bedroom units as well, which was really important for that component of affordability that we need to build up.
Okay, great, thank you.
Thank you.
Sabrina, did you? No? Okay.
Thank
All
you.
right, thank you very much, sir. Okay, I don't think we need the applicant back up to refute the support. So we'll take this into committee. Dino.
Can I take this one? I keep saying that I know properties, but I know these properties quite well. Let me start with the first one, which is 1095, 1111 Danforth Avenue. So this is a site that contained St. Catherine's of Siena Church, which was our parish church for many, many, many years. And I visited it as a child, and our family did as well. Unfortunately, is no longer there, but had been there for about 50 years. Next to it also was, unfortunately, a funeral parlor, which we also had to attend on some occasions. This is an area that is well-serviced with parks, community services. Across the street is Greenwood Tower, which is a 350-unit affordable housing development built in 1972, 15 stories. This location is on a well-serviced transit route, both public transit, obviously above ground, but also Line 2 subway. The applications, both of the applications, are minor alterations to development standards. I certainly think these are an appropriate location for this type of housing development, and I am prepared to move with support of my colleagues the approval of both.
Why don't we, since they are separate, listed on the agenda, let's do them individually.
That's what I was going to suggest.
Okay, so why don't we start with item 24?
All right, so I'll move to approve the application and the variances, the 4 variances requested, subject to, I believe, there's a condition from transportation with respect to payment in lieu of bicycle parking, with respect to the parking program. And there's also, again, I believe there's a TTC condition, 2 and 5. So I'll move it with those conditions.
All right, motion by Mr. Lombardi to approve with those 2 conditions, seconded by Mr. Gauche. You have a comment?
Yeah, with a comment, just in case there are any francophones watching. It's Théâtre Français de Toronto.
There you go. Thank God someone corrected us. Well done. Seconded by Mr. Gauche. All in favor? You have your approval. Thank you.
Thank you for that.
Dino, do you want to take 25 as well?
Yes, this is 1117 Danforth Avenue. Also, I'll move to approve the application and grant the 3 variances being requested. I do not see any conditions of approval that have been recommended, so that's a simple recommendation.
Through you, Mr. Chair, do we have
Is TTC in that one as well?
TTC 2, 3, and 5?
Oh, okay.
Yeah.
And do we have also transportation services?
I did not see those, but I stand to be corrected.
No, nothing from them, sorry.
I thought there was TTC on both.
There is TTC on both, yes, but TTC for this item is conditions 2, 3, and 5.
Okay.
There is a planning report, but
It's
it's just for
information.
information,
Yeah.
right?
Okay, yep.
All right, Dino, you okay with all that?
Yep, 2, 3, and 5, yep, TTC, yep, with that condition.
Motion by Mr. Lombardi to approve, subject to those conditions, seconded by Ms. Plaitzer. All in favor? You have your approval. Thank you very much. Thanks for coming down.
Thank you.
Sir, I don't mean to call you out, but are you ready to come back?
Yes.
All right. So you'll get the microphone back to you. We, just for the record, I'll say we are returning to item, which one is it? 23. Item number 23. Yeah, get out of here, Ryan. 523 Delaware Avenue. The owner has returned, and you've got some adjustments for us?
So, spoke with my wife and our engineer. So if you are looking at the plot that is our usable space, meaning not the part on the other side of the fence that's the neighbors, if we remove the current pavers that are in our backyard that are in front of our garage, as well as change from a cement to a permeable soft landscaping for that secondary parking spot, leaving in that row of pavers gets us to 46% green landscaping. And the reason I caveat it by saying leaving those pavers along that fence is that our engineer had been in communication with the city, and they had told him that those should stay in place. So I want to give you a number on the assumption that we can't change those.
Okay, that's very helpful. So 46%, and do you have the square meterage?
That I don't have off the top of my head.
We're gonna need that. So if you've got the percentage, someone somewhere has the
Yes.
square meterage.
Through you, Mr. Chair, maybe we'll unmute your agent, and they'll be able to, yeah. Mr. Kim?
Hello, yeah.
Okay.
Yeah, so basically we are adding 24.7 square meters, so it's gonna be total 56.4 square meter, which is 46.4%.
Did you get that?
Sorry, can you say that one more time?
So we are adding 24.7 square meter, so total is 56.4 square meter.
At 46%.
0.4%, you said, I believe.
46,
0.4?
yeah, 46%.
So it's 56.4 square meters
Yeah,
at 46%.
yeah.
Okay, there you go. All right. Thank you very much. Thank you, sir. Just hold on here a second. We do appreciate that. That makes, I think, the application a whole lot better. Your neighbor did speak about, having some discussions about cladding. We can't make that a condition, but you may want to have discussions with him about cladding for your addition. Any further questions of this guy? Okay. Then let's go into committee. Who wants to take this one, Phil?
Sure. So I think that was extremely reasonable on the part of the property owner.
Yeah.
And it improves the application, the variance that's left. So rather, it's 50%, right? And so now now it's, was it 46? 46? I mean, that truly is minor. So it improves the property. It alleviates some of the concern about the drainage, and the remainder, putting a bump out at the back of a home to create a little more usable space in it, with an extremely minor FSI variance, and every other variance is very minor. It makes sense, it's good use, it's good planning. So I would move to approve it. I will still impose the planning condition that it be permeable under the deck as well, which probably more than compensates for the last 4%, but subject to the planning condition as amended. I would move to approve it.
Okay, motion by Mr. Ghost to approve, seconded by Mr. Lombardi. All in favor? You have your approval. Thank you for your changes. Okay.
So that was as amended, right?
Yeah.
Okay, yep.
Okay, we move on to our last item of the day. 3434 Dundas Street West. This is an application to construct a new 5-story detached medical office building. The 5th level will contain a front outdoor terrace area and indoor fitness area. There will be a total of 30 surface parking spaces, including 2 accessible parking spaces in the rear yard, accessed from a mid-block driveway abutting Dundas Street West. Committee has before a copy of the plan of survey, site plan, floor plans, and elevations, covering letter from the agent, transportation study, a tree inventory plan, email correspondence from Urban Forestry and from Transportation Review, and a staff report from Metrolinx. Hello, sir. Good evening. Oh, I'm sorry. I keep on interrupting. I should know my place by now.
Through you, Mr. Chair, we have the agent here in person. We have 1 registered speaker in support, and we also have a speaker that will be on standby for questions. Well, correct?
Okay. Now, sir. Good evening.
Okay.
Name and address, please, sir.
Good evening. My name is Bruce Hall, and my address is 215 Spadina Avenue, Suite 120, Toronto.
Okay, well, first of all, thank you for sticking around to the bitter end.
Our pleasure.
And since you've come down and you look like you're on force, maybe just a quick overview of what you're proposing.
Sure. I realize you've had a long day and probably
have
want to
you.
get out of here, but this is a very important project for Runnymede, and I wouldn't want you to make any decisions on it without hearing the rationale for the minor variance, but also what the project is about. Just to say very quickly, we have representatives from Runnymede, one of the directors, our architect, and our transportation consultant. We're not going to come up and give you any more detail than that, but they're here to answer any questions from their respective positions. So Runnymede is a healthcare center that's a very dynamic and evolving rehabilitatory and a very complex continuing care hospital located on Runnymede, just south of this site. And currently it serves as one of its roles first responders in Ontario with critical healthcare services. And why this is so important is, if you could bring up my presentation, I would appreciate it. 23% of first responders suffer from PTSI, post-traumatic stress injury, at some point in their careers, which is very tragic. But Runnymede is there to provide them with care and support. And the PTSI Center of Excellence, or Station 3434, it is also going to be known as, is the first dedicated facility in Canada that will deal strictly with PTSI for first responders and healthcare workers. And their goal is to get them back to work and back to life. Runnymede has funding commitment from the province already for this, and this has been going on for a long time. Gila and George have been working on this since 2000. We've met with community planning at least 5 or 6 times The building started off as a 9-story and 7-story building. It's been refined to make it almost zoning compliant with respect to all performance standards. Next slide, please. It's a very good site. It's right on Dundas. It's in an employment area. It's an employment use. It has good transit, surface transit, and it's about a 7-minute walk from the main Runnymede campus, which allows certain functions to be shared. Next slide, please. It's in an employment area, which is a growth designation, and this is going to be a vacant site that's going to be intensified with a 5-story compact building. Unfortunately, it has the old zoning. It never made it into 569/2013. It's employment zoning, and we really want to, we're still going to comply with all that zoning, but we want to size the parking appropriately. Next slide, please. It implements a lot of important key provincial and city planning objectives around employment. It's transit supportive, very strong urban design. As you can see, the buildings at the street has a very strong street presence. You'll be able to see into the building. The parking is hidden in behind, and it will really enhance the streetscape. People talked a lot about that tooth today, and this is a vacant site. So next slide, please. The minor variance is really about the parking standard, and the way that this application was submitted, we want the city, the Committee of Adjustment, to apply the new standard in the new zoning bylaw, which is a parking maximum. The way that the notice was done really described the project as having 30 parking spaces, and it's requested that as a variance. That's not what we want to do. We want to put in the parking minimum, which is in the new zoning bylaw, parking maximum. And we've had discussions in the last few days with both planning and transportation, and there was a new transportation letter added, and they support applying that maximum parking ratio. Notwithstanding that, the proposal is for 30 parking spaces. We just want a little bit of flexibility. We're going to be applying for site plan approval, and through that, if there's a slight reduction in something and we end up with 29 parking spaces, we don't want to be back here. I'm not going to go through the 4 tests because I believe that it meets the 4 tests. It is minor. Right now, if we went in under the new zoning bylaw, 0 parking spaces would be required, so we're going to be providing 30. And I think it, it meets, obviously, as I've shown, the intent of the official plan and the zoning bylaw. And I do believe it results in very desirable development because it helps a lot of people. It furthers, a lot of city objectives around active transportation and transit and employment. So I'll leave it at that.
Great, thank you very much, sir. Okay, panel, questions? Dino?
Just very quickly, thank you. And I think you may have answered the question, but I was reading the justification report that was prepared by the Planning Partnership, which is dated November the 5th. And on page 3, the statement is made that the proposed development will provide approximately 30 or so service parking spaces, which I found interesting as terminology. Typically, you don't say, 30 or so at the rear, and then it goes on to say, although that is to be refined at the site plan process stage. So that's what you were talking about when you referred to.
Exactly, and I do hope that the updated letter from transportation was provided to you. It was done late yesterday, and Dan Reynolds does support that's it right there, does support the application of the parking maximum, and says if it ends up being 29, they're okay with that.
Okay. So just to follow up to that, so I'm concerned that if we approve this application and the variance, which requests 30 or considers a total of 30 parking spaces, and the site plan through that process, that is reduced somewhat, and this applicant goes for a building permit, they're going to review our decision and apply that to what they see in the drawings. So is there going to be an issue if we grant the variance, we approve the application, grant the variance for a total of 30, but then in the end it's 28? I don't want.
You don't want
the
to lock it
applicant-
I
down?
will,
So are you concerned about that, sir?
Through you, Mr. Chair, the request is that the standard of a maximum of 6 parking spaces per 100 square meters be the established standard, the variance, and really, all you're doing is bringing forward the standard in bylaw 569, 2013, and something 22. Yeah. Yeah, and that's the standard that the city applies across the board now, so.
The problem that we have, I think I'm going to say what Sabrina is about to say. The problem that we have is we're not allowed to reduce at a hearing increase the severity of a variance request without giving notice to the public. And the way that it's worded right now, and this is what my colleague Mr. Lombardi was saying, it says 30 spaces. So our concern is that if we approve your application, I think I probably speak for the whole panel in saying we only wish the best for this application. And our concern is approving the application might not be the best for you because it might be a decision that doesn't give you the flexibility for the interpretation that you're now saying you're working out with transportation services and want. Because the decision will read, they applied for 30. And even if we wanted to say we would grant you a variance for 0, we can't do that because we haven't given notice to the public of less than 30. So your best situation might be to defer the application to send out a new notice that has a smaller number of parking spaces. But I think if the advice of your team was you wanted to go ahead anyway, I don't think it would be any problem. We would grant the variance. We're just worried about not doing you any favors by helping you.
So, yes, so through you, Mr. Chair, that's correct, but what's before us today is a variance under bylaw 1-83, not
I
56, not 569-2013, right? So the bylaw reads that a minimum of 65 parking spaces are required. There, right now, show 30 surface parking spaces, right? At the time that it goes through site plan, right, there could be discussions between transportation services and zoning staff.
To not even apply this bylaw. So
Exactly,
this variance becomes moot.
they would just apply 569-2013, which obviously gives them minimum 0, so anything that they provide is additional, and then they won't have any issues. So if I was the applicant,
Not giving advice.
no, they may just want to move forward with today's application, really try for
'Cause
the
then at least they
30
have this in their
surface
back
parking
pocket.
spaces, but understand that there's going to be additional conversations as part of the site plan control application, and that it may actually be a better situation.
That was really helpful.
That was very helpful. Sir, so I presume you totally understand all that? Okay. And
I do, and
how-
and I appreciate the dialogue. If I can just explain, when we applied for the application, we asked, like we gave a wording for the variance, and we asked for that. The issue was, the notice was prepared, and I had a conversation with the technician, the clerk, about this. It was because that was what was in the ZAP, or the ZBR. But it was very clear that we wanted that, and we wanted to have the discussion, but the notice went out that way. I mean, I understand you're being very careful about notice and the way it's approved. In my mind, the notice is more of a description of what the proposal is with the parking, what and whatnot. And, you know, we were very, very clear on what we wanted. And I spent quite some time going back and forth. And by the time I got back, because I actually ran into Dan Nicholson at Community Council, and I brought this up, and I said, we really want to resolve it. And he did have some discussions very recently with Dan Reynolds, and that's why that letter came about. But in the meantime, the notice had gone out. So it's very unfortunate that that's the way it happened, because I think everybody would have supported it if that was the letter, what was before you. So if you're telling me, based upon that notice, that you cannot go to the alternative standard today, then I think we're just going to push forward with the 30.
Yeah, and you've got a fallback, right, in terms of getting into site plan control.
Yeah, I mean, I find when you get to zoning, if there's been a minor variance, they're more likely to look at that as opposed to the bylaw. And I'm looking at my transportation consultant. It could be, yeah.
So, okay, so we're actually just trying to, I think we like this proposal, we want to support you, we just want, don't screw you up.
It's just point of clarification. What transportation staff is saying is going to be different than what Toronto Buildings is saying, because Toronto Buildings is looking at the regulations under the zoning bylaw and what applies. And zoning staff is saying what applies today is from the regulation of bylaw 1-83. Transportation Services is just looking at your parking study and saying, yes, you know, we can allow for less than 30 parking spaces. But at the end of the day, if zoning staff does not agree with the variance that's been before Committee of Adjustment, they won't issue you a building permit, and then you get tied up in that. So because you submitted a zoning review and it's the regulation under bylaw 1-83, that is what's before committee today. And then through your site plan application, you'll have to work things out between zoning staff and transportation staff.
We're being very cautious. We think we can make it work, and we hope we can make it work, and we will try our best, obviously even more so now. We just wanted the flexibility, and it made sense in terms of trying to implement the new zoning bylaw. So, yeah,
It sounds like you've been at this for 25 years.
Me personally?
Well, somebody has in terms of this thing. So we're just in your hands, like
Yeah.
how you want to proceed.
Yeah, I think we'll proceed. Yeah, I'm getting nods, so yes, thank you very much.
And, again, we were just trying to, out of an abundance of caution, we didn't want to tie you up in knots that would have set you back. So we just want to help you out however we can. So if you want to proceed with this variance, that's great.
Yeah, and we appreciate, the discussion about waiting and deferring. There's a really need to push ahead with this. We've been at it for a long time, and there's funding. And George has been given orders to get this done in 2025.
If you've got funding, you better leap on that fast.
Yeah. Thank you.
All right. Thank you very much. Yes, another question?
Yeah, one more question. So is the whole building going to be run by Runnymede Health? Nothing is being leased out to anyone else?
Correct, yes.
Okay.
Yeah.
I ask this because there's a proposed Metrolinx condition that came in, and to me this sort of highlights why I find these Metrolinx conditions a little not appropriate for us to necessarily impose, and a case like this perfectly highlights it, because it comes in a standard form saying, and you're offered a lease and purchase and sale include a warning clause, and that's just not even going to happen at this property.
Yeah. I mean, there may be a cafe or something like that, but nothing.
But who's not going to know that a train track is behind it?
Yeah.
Okay.
I appreciate the concern.
The
Yeah, thank you.
noise and vibration study is part of the Metrolinx, right?
That'll get captured as part of site plan control.
Okay, the noise and vibration study,
If you
okay.
don't feel comfortable imposing.
So we don't need to go there.
I had, you know what, the noise and vibration I hadn't seen, so that's.
But Sabrina says that'll get caught up in site plan, so
Yeah.
we're probably fine standing it aside.
Yeah.
Okay.
Are we going right to committee?
Yeah, so any further questions? No. Okay, we're in committee.
So,
Oh,
my first ever career was as a paramedic, and I'm friends with a lot of paramedics, and some who have PTSD, And this is a life-altering injury. It really is. Station 3434 is a really witty name. I love that for a place that will service our important frontline workers. I see fitness area, outdoor, social, and barbecue area. This is a really well thought out project. I think the design and aesthetic are an improvement to the neighborhood. So I think I'll let my colleague, Mr. Lombardi, speak, but
Would you like, no, I was just gonna move a motion.
yeah, I'll happily turn this into a motion to approve the variance. We're not gonna include any
No conditions.
Metrolink's suggested conditions, so yeah, I'll move the motion forward.
Motion by Mr. Bissonnette to approve, seconded by Mr. Lombardi. All in favor? You have your approval, sir. Thank you very much. Congratulations. It's as you say, it's a wonderful project. We couldn't support it more. The discussion was just to make sure we didn't bung you out.
That was awesome.
Thanks very much. Thank you very much.
Okay.
First responders are very supportive, and it's good to have your support.
That's great.
Thank you.
Thank you very much. Thanks for coming down and sticking around to the bitter end. With that, that concludes today's session. Is it 7:31?
6:50.
It is 6:51 p.m.
6:51 p.m. That not only concludes today's proceedings, it actually concludes the 2025 TEY hearing. So for everyone, all the best for the holiday season. Thank you, staff, as always, for such a great job. Thanks, panel. And we'll see you in the new year. Well, so see you on Friday.
Thank you. Yes.
See you on Friday.
Thank you, Mr. Chair.
Okay.